No mention?
May I please also? Item number 19, my lord. This matter may be allowed to withdraw this petition, my lord.
Withdraw.
Yes, my lord.
Item?
19.
You have received the salaries.
Yes, my lord. Some arrangement is there, my lord.
Okay. Who is appearing for the other side? Anyone in item 19?
Elementary education.
Heard Mr. UJ Saikya?
A go high.
A. Gohai, learned counsel for the petitioner. Also heard Mr. SNCST, learned steering counsel, elementary education. Stop. Mr. Gohai, learned counsel for the petitioner, submits that he has received instructions from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the same. Prayer is allowed. Writ petition stands dismissed on being withdrawn.
Lordship, with the consent of the other side, I recommend item number 18, Lordship.
Item number 18.
There was direction to bring the.
You are for MS?
M. Bora on behalf of SP Children.
As prayed for by MSS
M. Bora.
M. Bora, learned counsel for the respondent with consent from the petitioner side, relist after 2 weeks on a date to be fixed by the registry.
Item number 30.
I'm closing it.
Mal.
Agitated order to hold on. I'll dictate it inside.
Mal.
For admission, item number 1 and 2.
May please. May please. The matter pertains to non-promoting the petitioner to the post of LDA.
Sorry?
Matter pertains to non-promoting the petitioner from the post of grade 4.
What about the rejoinder?
Rejoinder is there,
You have filed?
Okay.
Non-consideration for promotion to the post of
LDA,
LDA.
While the junior has been promoted.
Acha.
The case of the petitioner is there, She was appointed on 3/3/19.
I'll admit it. Pranav? Heard, Mr.
There is similar or various orders, on this point,
It needs hearing. So I'm admitting it and I'm posting it for hearing in the month of June. Your name?
PG again.
Heard Mr. PJ Saikya, learned counsel for the petitioner. Stop. Also heard MSMD Bora, learned standing counsel. Corporation. Stop. The matter requires full-fledged hearing. Admit no formal notice as parties are represented. List for hearing in the month of June 2025.
Maybe they fix matter. And
In June, you are for?
item number 2, man.
He is the petitioner,
And the petitioner man over here, I am hanging because of the stay order.
This is 1 and 2 is tagged.
Yes, ma'am.
But there is interim order that may be continued.
Interim, if any, shall continue till the next date of listing.
Obliged.
Kindly date may be fixed, man.
Yes, I have fixed it.
11.
Obliged.
Number 3.
Dismissal from service.
May it please your lordship, my lord. My lord, history of litigation, my lord, and this is the 4th time I am before your lordship, my lord. What happened in this case, after a departmental proceeding, my lord, the petitioner was dismissed from service and the charges was unauthorized absent, my lord. Petitioner, he was appointed as a messenger cum sweeper, my lord, in the Swansea Gaulia Bank, and that bank has been merged with the Assam Gramin Vikas Bank in 2006, my lord. So, and his period of unauthorized absence was from 1/7/1998 to 8/6/2000, my lord.
You are
Okay.
challenging the
Yes.
merit of the order or only the proportionality of the punishment?
Both, my lord. I'm taking both the grounds, my lord.
Any procedural
first-
violation?
Yes, my lord. They, in the major penalty which they have imposed of dismissal, my lord, they have taken past records into consideration. And as your lordship knows, there is numerous judgment of the Honorable Supreme Court saying that if past record is going to be taken into account, then it should be there in the letter of charges. But in the letter of charges, there is not even a whisper regarding any past records, my lord. So that ground also I am taking. And another ground which I am taking is regarding willful absence, my lord. I
Alright,
would,
I'm admitting it.
lordship,
Heard.
the only problem is that this man, he is already 58 years of age and he's
Heard
going to
MS
JM,
J.
JM.
JM Kaur, learned counsel for the petitioner, also heard Mr. A. Ganguly, learned counsel for the respondent. Stop. The matter requires full-fledged hearing.
Short
Uh,
that, my lord. Otherwise,
sorry.
he's already 58 years of age. A date may be given.
Please, bear with the court while the orders are being passed.
Sorry, lordship.
What?
Sorry, lordship.
A full-fledged hearing, admit, no formal notice, as parties are represented, list for hearing in the month of June 2025.
Lordship, may I take your lordship indulgence? If a date can be given, my
It
lord.
will come in June as convenient with the registry.
Oh,
Yes.
oblige, lordship.
This is also regarding my lord, dependent proceeding, my lord, at the time of,
Yes.
at the time of regularization of the annual increment, my lord. I came across
These
the,
are completed?
yes, my lord.
Yes.
Well, I have been communicated with the order, my lord. That case of one different proceeding was initiated against me, and an order has been passed, my lord, where punishment was given, my lord, is my lord, withholding of my lord 2 increment with cumulative effect, my lord. That the order was never communicated to me, my lord.
What order was not communicated?
The punishment order, my lord.
Punishment, penalty order
Yes, man.
is not communicated.
Not communicated, and the inquiry report also not communicated, my lord.
Where have you taken all this ground?
Yes, my lord.
Where is the order?
Now, my lord, kindly see page 15, my lord. Where from, because it came to my knowledge, my lord.
You are challenging the order dated 24/5/2020.
No, my lord, page 15, my lord, 1720.
Huh?
My lord, in page 15, my lord, clause 2, my lord.
No. What are you challenging?
But this department proceeding number 12.99, DO number so and so dated 24/5/2000, my lord.
Correct, that's what I said.
Yes,
So
my lord.
you're challenging the order dated
Yes, ma'am.
24/5/2020.
Yes, ma'am.
Whereby the petitioner was awarded with punishment of stoppage of 2 increments.
Yes, ma'am.
Correct.
This order was not communicated to me, my lord.
And what is the order of 29/2020? Appeal.
Yes, my lord.
Your appeal was rejected.
Yes, my lord.
All right. Now, which page you want this court to go? Page 15.
Page 15, my lord.
Yes. What do you want to show from
My lord,
page
clause 2,
15?
my lord. But it is our order, my lord, 31/2020, my lord.
Which clause 2?
Yes, my lord, paid raised from so and so. 50,802 rupees so and so with effect from 1/7/2002 instead of so and so as he was awarded. Established 2 annual increment with cumulative effect in connection with the dependent proceeding number.
So
2.
you want to say that on 13/1/2020 for
Yes,
the
ma'am.
first time you have come
Yes,
to
ma'am.
know that such and such penalty has been imposed on you.
Yes, ma'am. And rule says, my lord, it should be communicated to me, my lord.
Yes. Then
Then, but thereafter, my lord, I preferred an appeal, my lord. Page 18, my lord, where I have taken all these grounds, my lord, that the inquiry report has not been considered,
yes, please read.
but it was addressed to my deputy. Inspector General.
Read the
Yes, ma'am.
I said that
I said I could not prefer this appeal. This is for my lord, the appeal within 6 months in view of the proviso of clause 9 of the Rule 60 of Assam Police Manual Part 3 proviso 9 or Rules 60 of Assam Police Manual Part 3 provides no appeal shall be considered by the appellant authority if it was not preferred within the 6 months after date on which a copy of the order appeal against was communicated to the appellant and no reasonable cause is shown for the delay. In the present case, I have not been communicated with the impending award of punishment as yet, and for which I could not prefer this appeal on the basis of the award of punishment. In fact, prefer this appeal on the basis of the contents of the order dated 31/1/2020 issued by the Superintendent Police Board Assam, which spelled out about the award of punishment. As such, your question be pleased to condone a delay in preparing the appeal, considering the aforesaid facts and circumstances. Page 19, madam. So far, the dependent proceeding 12/99 is concerned. I say the same was initiated while I was posted at Ring Police Station as officer in charge. That white letter under memo number so and so dated 27/11.
Mr. Goswami, are you reading? a lot of allegations are there. You have to show from your affidavit that this has been complied. Because they are saying that they have also not received any notice to participate in the disciplinary proceedings. These are allegations. That's why I'm saying you have to
Paragraph 9, Lordship.
9 of.
9 of my affidavit.
All right, I'll come to your affidavit. I'm just let me complete page 19 first.
Yes.
But a lot of things have been said that you have not given them a copy of the departmental proceedings. Then they had asked for
Inquiry report, madam.
some list of witnesses and
List of
documents
witnesses.
was not given. A lot of things have been said.
Lordship.
That by letter under memo number so and so dated 27/11/99 issued by the Superintendent of Police Nagaon, I have been served with the so-called notice along with the statement of allegation under section 7 of the Police in 1861, reading which Rule 66 of Assam Police Manual Part 3 and Article 311 of the Constitution of India for not handing over 16 number of case diary to my successor at the time handing over the charge of the police station.
What happened to this appeal?
Now, madam, the appeal has been rejected, madam.
Page 21.
Yes. No, madam.
Yes, page
Yeah,
21.
yes, no, yes,
Correct.
yes. Ma'am. Page 21. And the punishment, madam, which has been imposed upon me is not enlisted in the rule also, madam.
The appellate authority doesn't seem to deal with the contention raised by
Yes,
the
ma'am.
petitioner. The order prima facie appears very cryptic and mechanical. Nothing has been said. It simply says, after careful observing the relevant papers, file, it is seen that the findings submitted by the inquiry officer is satisfactory. Since the delinquent did not submit 7 numbers of case diaries to the Honorable Court at the time after being shown disposed of. Further, he did not submit another 6 numbers of case diaries after 1 year of his transfer, which is highly not accepted in a discipline force. Hence, I stand with the order of the then so and so. But what about the contention that has been raised? Nothing has been dealt.
That is not the answer. Lordship.
Huh?
That is not the discussed. Lordship.
Correct. Now let us see what is your stand in your affidavit.
First, I would like to this page number 37, Lordship. Page number 37, Lordship, paragraph 7. Relevant portion, Lordship.
1 second.
Yes.
Yeah, 37 is the AO. Yes, the
Yes,
relevant.
Lordship. Paragraph 7, Lordship. The relevant portion, Lordship.
Yes.
As per the records as evident in the first source, a notice of the petitioner issued by the Superintendent of Police Nagaon Height so and so dated 27/11/1999. The list of the documents and the list of the witnesses had been served to the petitioner along with the so-called notice, which was received by the petitioner on 1/12/1999 by putting his signature. Lordship. It means a list of the evidence, documents, and so-called
Yes.
was furnished. Lordship. Now, Lordship,
What at what page is this receipt? Just give me the page number. That annexure?
yes, Annexure C, Lordship.
Yes, page.
Page, Lordship. Annexure C, page, Lordship, it is 43, 43, Lordship.
All right.
43,
Then next.
page 43. Now, Lordship, the written statement
Was submitted on
yes.
10/12.
as per records on
All right.
10/12/1999,
Then-
written statement submitted, Lordship. And paragraphs 9, Lordship.
Yes.
The inquiry officer was appointed, Lordship. His Lordship, the KK Boyso, APS, then additional SP, Nagaon, Lordship. At that time, during the inquiry, the delinquent, Lordship, the petitioner was in Nagaon, reserve.
Police reserve.
Yes, police reserve. Lordship. Accordingly, the additional SP Nagaon issued 3 notices to the petitioner and the prosecuting witnesses to
Where are these notices and what is the proof that he has received? Because he says he has not received any notice.
Lordship. That is not annexed, Lordship.
No, but that is the crux.
Yes, Lordship.
This is the allegation, you see.
I will go through the record.
You
Lordship.
have, that is why I asked you,
Yes.
Mr. Goswami,
Yes.
allegations are very serious. allegations are very serious. If you can show it from the record that yes, you have given all the due opportunities, which one delinquent is required in law to get, then this court is not going to sit and appeal against the inquiry officer's report, correct? But the allegations are very serious. That you have not given him any opportunity, notice of inquiry, what has happened, he has not been given opportunity to participate. A lot of things have been said. Then the inquiry report, he says he has not been communicated with the inquiry report.
They are silent, madam.
So if you have the proof here, you can show me.
So for Lordship, regarding the notice, Lordship, we has written it, Lordship, regarding the notice. Regarding the notice, Lordship, we furnished him the notices, Lordship.
That is your submit. That is what you have stated.
Therefore, Lordship, kindly allow me to
You have a look.
submit.
But they have annexed the notices also, madam.
They have annexed.
Yes, please.
Where are they?
Page, madam, 52 onwards, madam.
Page
52 onwards, madam.
52 is the departmental proceeding report.
No, 52, madam. They have annexed, madam. My
The
affidavit, they have
52
annexed.
is
madam.
not.
52.
But is a WT message, madam? Sent to the madam, the listed witnesses, madam.
And what about your name?
Madam, ASI Upendranath Sharma, madam. Police
Yes.
reserve, so and so.
It
So-
says appear before me on so and so
So
at
and so.
so and
But
so.
my receipt signature is not there, madam.
Yes, it is not there.
No, it is there, Lordship. It is.
So you verify.
Page 54.
But three notices they have annexed, my lord.
No,
If
page
two notice
54.
52, 53, man, there is no signature of
Page?
petitioner, madam.
It is
53, madam.
54. Page 54.
UN Sharma.
Yes.
This is
All is
there.
one notice, my lord.
But
On
he
what
stated
date they
that
have, my lord?
he has no
No,
knowledge
but
about
you see,
the-
Mr.
Yes.
You have made a specific allegation that
Yes, ma'am.
nothing has been communicated. You had no idea. This shows that you were aware of the
Madam,
next date
madam,
fixed. Anyway,
I
you
have taken it down, my lord.
you
How
have a
this
look at
happened, my
the records and when Tuesday,
Lordship, Tuesday, Lordship.
Tuesday. We'll see if it can be disposed of at the admission stage, because that is all that
Lordship.
has been argued. So if
Can
you
it be
can
on Friday, Thursday, my lord?
Thursday, all
Yes,
right. Heard in brief, relist on Thursday. Let the records be placed before this court on the next date of listing by Mr. J.K. Goswami, learned additional senior government advocate. Relist on Thursday, date to depot on such and such date for further hearing.
Number 5.
Yes, Ms. Priya.
Pleases. Lordship, person with-
Re-examining what answer scripts,
yes,
post in Assam Financial Service.
yes, your Lordship.
Yes.
Pursuant to an advertisement dated 23/7/2018, your Lordship, wherein advertisement has been given for the post of finance and accounts officer.
Who has submitted? There are a lot of case law submitted.
Yes, your Lordship.
You have submitted.
Yes, and they have also submitted, I presume. Because, your Lordship, there are diverse of opinion of the Honorable Court as well as Honorable Supreme Court. Some are saying the answer script cannot be produced. Some are saying it can be produced for inspection of the petitioner. That much I want, your Lordship, for my satisfaction, because I secured first class in the subject financial rules and accounts, wherein I secured 199 points, my lord. And Viva Voce, I secured 44 marks. And the cutoff date was 252 for male in the open category. I belong to general category, Lordship, but I have just lack of few marks, 243, my lord. So because, Lordship, I have got full confidence that I have secured more marks. Just I want to have a look. And they are saying the answer script is available before this with them, your Lordship. Since the rule doesn't permit, so they cannot produce it.
What is that rule?
Lordship, my case is that it's of 2010 rule will be applicable.
Under that
Lordship,
rule, there is a bar.
there is a bar, they say, my lord, but Lordship, they say my case is covered under Rule 18, but your Lordship, it is under Rule 10, my lord.
Please read.
Lordship. Lordship, subsequent rule was amended rule was of 2019.
Hmm.
Our advertisement is of 2018. So my submission is that rule of 2010 would be followed.
As per Rule 10, there is some bar for re-examination of answer script. You are appearing for APSC.
Yes.
Under Rule 10, there is a bar. What is it? Just read it. Just read it.
I can propose.
Read it.
There is a lordship regulation. Regulation is called Assam Public Service Commission Procedure and Conduct of Business Rule 2010 lordship. And there is also some clerical mistake on our applying then that we have quoted 2019 rule, but it should be 10. And we have made it confirm in our affidavit in opposition. That 2010 will be applicable. lordship. And will-
So you
Page
admit that
12.
position that
Yes.
2010 is
10
applicable.
applicable.
Now under
Under
2010 rule,
2010 lordship.
Which one?
Lordship can go to page 12.
yes,
70.
rule
70.
70.
Yes.
Yes,
17 4 lordship.
70.
70,
74.
70.
Yes, read.
74.
Yes, the commission shall not entertain any request for re-examination of answer scripts from candidates or from any other persons. So this, it appears there is a bar.
Lordship,
Ms.
but
Priya.
I have come across certain judgments wherein it has been diluted. In
Now,
case of,
despite there is a rule.
yes, it has been
Alright, then fix
diluted.
it for- admit the matter and fix it for hearing then.
And
Need some
although they
re-examination.
say that it was not available, subsequently, my learned senior friend, Mr. T.J. Montefiore, submitted before this court. The answer scripts are available. my
It's
lord.
available. I have not.
Correct, but
disputed.
not there.
you see, Ms. Priya, at
Yes.
least this much adjudication has to go,
Yes,
whether despite there being a rule which prohibits the re-examination of the answer script can
my
that
case
be
is
done.
not for re-examination, just for my satisfaction. This is my paper.
You
I
want to
don't want any
inspect.
third party
You
interest.
want
It-
inspect, you want to
Just I
inspect.
want to have a look, my lord. And it was allowed by earlier honorable court judgment. This
Show me,
honorable court is
show me.
entertained.
Tell me what judgment you have.
Lordship. In the earlier occasion submitted before this honorable court, it will know, honorable.
Just tell me the name because there are few
I'll-
judgments here.
Yes, yes.
But in your
Lordship,
prayer, you have said to re-examine or re-scrutinize.
Yes.
So please make up your mind. You want to verify or you want to re-examine and re-scrutinize?
Re-scrutinize, it includes inspection, my lord, of the answer script. And under Article 226, your lordship, any order.
Only if I find that there is some illegality.
Yes.
You see, if there is some illegality, of course,
Yes.
the arms
My
of
lord.
this court is long enough
Yes,
to
lordship.
reach wherever there is illegality.
On the
There
last.
is no
occasion,
difficulty,
Lordship,
but that much
satisfaction.
satisfaction has
Yes.
to be generated
lord.
first.
Lordship, I, on the last occasion submitted one judgment, writ appeal 259 of 2016.
259.
Yes, it
Yes.
was there probably.
Yes, yes.
As APSC was a Papuri Deka.
Yes.
Therein, by now, para 10, your lordship may kindly have a look.
Yes.
The decision referred to is duly considered by this court, and in the same breath, it is clarified
Para
that just.
10.
Yes.
Para 10 starts with today, Mr. Borua.
Oh, no, my page, para 9, today, Mr. C. Burwal, Learned Counsel.
Then
Para 10. The
para.
decision referred to is duly considered by this court.
One second, one
Hmm.
second. I'm not getting that para.
Ujjwal Bhuyan.
There are two decisions of. There are two. They both. No, they both are of same date only.
The line starts, my lord.
Hmm.
The decision referred to.
Yes, this is. Yes, now you can read. Yes,
Right.
I've got it.
is duly considered by this court, and in the same breath, it is clarified that the judgment relied upon by Mr. Burua do not come to the aid of respondent authority. Now, the same is applicable in the facts and circumstances of the instance case. It is made clear that this court is not reviewing the actions of either the scrutinizer or the examiner, nor is undertaking any exercise in allowing higher or lower marks to the petitioner. The only exercise that is undertaken here is to ascertain what marks had been awarded by the examiner to the petitioner, as against question number 1B of the General Studies paper. The role of this court is only to the aforesaid extent, and while doing so, the court is satisfied that original records that the answer scripts of the General Studies clearly indicates that the petitioner was granted 9 out of 10 marks as against the question number 1B. It is also seen that the said 9 marks was not added to the total marks granted to the petitioner in a General Studies paper. The said exercise has not been taken by this court as an appellate body or by undertaking a review of the action of the examiner. To reiterate, the role of a court has been only to reinforce any marks given by the examiner to the petitioner in respect of the aforesaid question number 1B. So my contention, although I have not specifically pleaded,
Ms. Bria, anywhere in this decision, it has been held that despite the rule which prohibits re-examination, despite that the court can do that
No.
exercise. Anything on that
No.
line?
no, nothing is done.
Any other decision
Any other decision, one
on that point?
Yes, but the point that my learned senior friend Mr. T.J. Mahato fairly submitted, in one case, it was allowed by Honorable Division Bench.
Do you
Mr.
have that
Mahato,
copy?
Do you have? Excuse me.
Do you have a copy of that
I read it,
judgment?
okay.
Lordship, the issue of RTI reply by the commission regarding the answer script of the candidate was dealt with by the Honorable Single Bench of this court, which are in case. That case went to the division bench. Division bench, only for the satisfaction of that candidate, allowed to produce us to that answer script.
In fact, I was thinking of doing the same thing. I was thinking if the answer scripts are available, why don't you have it on the next day? That is why I was asking if there is any, if you can give me a handle, I can give that
Yes.
order right now.
Are you facilitating or not?
In that respect, yes, I am producing that order and
Sure.
instruction in respect of the order is before this, of course.
Related number.
Which order?
Read appeal number, let's say 183 of the question 21.
Read appeal number?
183.
83 of the 21.
Secondly. Yep, 182. 3581.
No, let's say
183.
183. 3581 was the original single judge order. And the appellate order is read appeal number 183 of the 21.
Do you have a copy?
Let's see.
Just give it. এখানে ডিডাকশন সাইলগ আছে নি এখানে সাইলগ
In this respect, Lordship, I have also obtained instruction.
The apprehension of the commission is that it will become a precedent. This court can always clarify that position that it will not be a precedent.
In idea case also that Deepak Prasad, Lordship,
You see, I have not seen this, but despite that, well, a grievance has been raised. There is no harm for this court to have a look at it.
Lordship can look into. Lordship can look into. But
That's what this court is
Yes, yes,
thinking
that
of.
too, my
but
lord.
the producing the answer copy to all the candidates.
No, I'm
Not all.
not saying about that. You can have the records, the answer script available, then let the court have a look at it.
Yes, we have no
What is
problem.
wrong in that?
We have no problem. We are duty forward.
Yes, and this is not.
And in that case, Lordship, candidate was average and he paid that he may be for his satisfaction, his answer script may be made available.
Here, the division bench allowed the appellant to see his answer script.
Yes.
That would suffice my case, my lord. My prayer.
Have it. Heard MSB Bhuya, learned senior counsel, assisted by Mr. T. Deori, learned counsel for the petitioner. Stop. Also heard Mr. PV Datta, right? Mr. PV Datta, learned standing counsel APSC, learned standing counsel APSC. Anyone else? Stop. The grievance raised in this writ petition by the petitioner is as regards the marks given in the which subject?
Lordship, financial rules and accounts.
In the financial
Rules and accounts.
rules and accounts in the examination held on
Advertisement, Lordship.
in the examination held pursuant to the advertisement dated
23/7/2018.
23/7
2018.
2018. Let the answer scripts of the writ appellant no, it is submitted by Mr. So-and-so, Standing Counsel Commission, that the answer script of the writ appellant is available. That being so, let the answer script of the petitioner be made available on the next date of listing. Fix list on such and such date. Yes, when?
May Lordship. 6th of May Lordship.
6th May. All right. You take back these, huh?
Obligement, Lordship will be kind enough to mention the this one, my lord, examination, class 1, grade 3 cadre.
Miss Bhuya, can you please ask
Yes.
your junior to
Yes.
just write it down?
Fine.
Doctor, I have to provide you in relation to examination of the details.
Obligement.
We kept the order to report.
Item number 6 and 7, my lord.
Yes, Mr. Dekka?
Yes, my lord. Items number 6 and 7, the subject matter pertains to the, my lord, of filling up 31 numbers of vacant posts of junior assistant in the,
Affidavits not filed?
in my case, my lord, no affidavit has been filed, my lord. But in item number 7, an affidavit was filed. And a copy of that affidavit has already been
Vidya, what
served.
about
Common affidavit.
common affidavit?
Actually, what is the fact, my lord? We then, my lord, high secondary admission council made an advertisement in 2018 to fill up the 31 posts of junior assistant. Accordingly, they prepare all these things. Computer test also, written test, computer test has been completed. Thereafter, my lord, what happened? It is required to be approved from the government as per regulation. So it's sent to the government. Government has rejected, and government rather directed the council to withdraw the advertisement. That is the fact. And now some interim order was there in different repetition. One of the repetition, Nilutpol, page 65. What's the policy? 65. One
Of
of the,
which case? 65 of?
this one, Malad. 7, item number 7, Malad.
Sound?
2852. WP show. Nilutpal Bhattacharya, page number 65.
1 second, I don't have that brief. 65.
Yes, 65, the relevant portion is the order is 66. By this order, my lord, the interim order was granted after hearing the last page, last paragraph, after hearing the Land Council for the parties and considering the entire aspect of the matter. Respondent Assam Higher Secondary Education Council.
Mr. Juna, from which page are you reading?
My lord,
Which page are you reading?
66.
66.
66. Last paragraph.
Yes.
After
After
hearing the
hearing.
London Council for the parties and considering the entire aspect of the matter, the respondent of Higher Secondary Council is allowed to complete the process of selection to the post of junior assistant in advertisement as advertised on 10 May 2018, which was published in 11/5/18 at the earliest on or before 30th April 2021, and to declare the result accordingly. Thereby completely said recruitment process is in accordance with law. If there is no other impediment in doing the same, by this order, my lord, government agreed. So I think, my lord, Advocate General FTA, my lord, the review petition filed. The review petition, what happened, my lord?
the court directed the single judge to take the matter on merit. Ultimately, this matter was dismissed.
Review
Review.
file it.
No, review petition is allowed. Review petition says you send back to the single judge. Single judge will pass an order.
Review
So-
petition.
Yes. Review
Yes,
petition is
then-
not an here, you know.
Review file before.
Review filed by the government.
Correct, but in review, how can that direction for reconsideration be filed? Review is reviewing the order of the single judge.
Single judge, but it might say the appeal.
Must have been an appeal.
Oh, yeah, maybe. but-
Mr. Then
Other
what happened?
Alagas matter also there, not only single, but
Then-
this interim order was rejected and disposed of the depression. Now the impediment is, we wanted to appoint and process, trying to complete the process, but government has come and government has said, no, you cannot do it like that. No approval is there, whether you do the advertisement.
Entire selection.
Advertisement. And this is the better. And now thereafter, what happened in 2000?
So the selection
No,
has
no,
not
but
been
not-
completed.
now
It has
it
been
is-
kept whole.
It was under the Assam Higher Secondary Education Council deeded. Thereafter, my lord, council dissolved and Seva dissolved, and with effect from 17 January 2025, it becomes one board. That is Assam State School Education
Right,
Board.
Mr. Dekar, this matter will need some examination.
Yes.
Have you filed your reply? Are you filing or you're not
Look,
filing?
No.
affidavit has been filed in my case, my lord.
No,
one
they
case
are
in
saying
common-
that
common
it's a
case.
common
The
affidavit.
same-
Yes, my lord, I'll file the affidavit in reply in
So
this.
you file-
affidavit, my lord.
Otherwise, I think, my lord, better become infrastructure because there is no
No,
council, there is no Seva.
In
Let
fact,
them
my
file
lord,
their
election
reply.
process is yet not been completed, my
Uh,
lord.
So no, there is.
All right, Mr. Chutia, I have heard you.
Oh.
Heard Mr. R.M. Deka, Learned Counsel appearing in WPC 7764 of 2022 and Mr. B. Chetri, Learned Counsel appearing in WPC 2852 of 2021. Also heard Mr. T. Chutia, Learned Additional
No, I
Senior
said, Security Council.
Learned Standing Counsel AHSEC.
Now it's asset, ASSED.
Okay, got it. So and so.
Earlier.
It appears that an affidavit in opposition has been filed in WPC 2852 of 2021. Mr. T. J. Sotial and Standing Counsel so and so submits that the said affidavit shall also cover the case in WPC 7764 of 2022. Mr. R.M. Deka, Learned Counsel appearing in WPC 7764 2022 seeks 2 weeks time to file counter affidavit against the said affidavit in opposition filed in WPC 2852 of 2021. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry.
Declare, right.
Alright.
Number 8.
My appreciation. Lordship.
Yes.
Lordship, in this matter, pleading is complete, Lordship. So let it be listed for hearing.
Dismissal from service.
Yes, Lord.
It appears that pleadings are completed. The matter requires full-fledged hearing, admit, no formal notice, as parties are represented, list for hearing in the month of August 2025 on a date to be fixed by the registry.
Okay.
Number 9.
May it please your lordship. Lordship,
Yes.
I have filed my affidavit in reply against the affidavit in opposition filed by respondent number 5 and 6. My lord, however, the same is not in record, has not come on record, my lord.
Affidavit in reply,
Yes, my lord.
you have received?
No,
Mr.
I am
Gupta?
appearing for
So he's-
respond number 1, 2, 3, and 8.
You have not filed any affidavit, Mr. Gupta?
Not required, my lord.
Not
because-
required. Mr. Fukan, you are for respondent number 6. You have filed your counter. And who has filed for 5? You have also filed.
To that reply.
You have filed reply against which affidavit?
The respondent number 5 and 6.
2 affidavits.
Yes,
reply
madam.
you have filed.
Yes.
All right. Mr. S.P. Sharma, Learned Counsel for the petitioner submits that a rejoinder affidavits against the affidavit in opposition filed by respondent number 6 on 4/2/2025 and against the affidavit in opposition filed by respondent number 5 on 24/2/2025 has been filed. When?
My lord, one today and one yesterday, my lord.
Has been filed yesterday date and Aji date respectively. However, the affidavits are not on, however, the said rejoinders are not available on record. Let registry verify and place the same on record. Yes, when do you want the matter
My
to be
lord,
listed?
My lord, at the earliest, my lord, because my lord will see the complaint, my lord.
You have not even filed any
Well, it's
affidavit
not
and
required
seems
at
like
all.
you
That's
are
what-
the
that's
one
what-
who
My
is
lord,
in
that's what I'm
urgency.
saying, my lord, it is not required at all. My
Yes,
lord will
Mr.
read the
Fukan,
complaint, there is
Mr.
no allegation.
my lord, may I just submit one?
List Thursday date to date
My
on
lord,
such and such date, next Thursday.
my lord, may I just submit here, my lord?
You've already filed your reply, let your reply come.
No, my lord, I need a leave, my lord. I need a leave.
You
to-
need what?
I need a leave to file an additional affidavit to bring in.
That we will see later. Yes. You haven't filed any
No,
application.
my lord,
Mr. Sharma, have you filed any interlocutory application seeking leave?
my lord, may I just submit here? May I just
We
submit
can
here?
see, let your reply be on record first.
My lord, next Thursday, my lord, I've been led by Mr. K. N. Chaudhary, my lord, senior advocate. My lord, may it be on 8th of May, my lord, because there's some difficulty for him. My lord. 8th of May, my lord.
Thursday, or Tuesday to date. Sixth.
Six, Obliged.
Much obliged.
May it be your lordship. Lordship, may please the last order, lordship.
What happened to the affidavit in opposition, BTC?
Lordship, may kindly see the last order. They are supposed to get instruction about the proposal.
Huh? BTC shall by the next date inform the court as to whether the proposal for regular pension payable to the petitioner has been submitted to the concerned respondents. The counsel for the BTC shall also produce the forwarding letter. Yes. This appears that everything has been completed.
Lordship, kindly see the petitioner retired in the year 2020.
No,
Since
but
then, he was a grade 4 employee.
Mr.
But-
Counsel, have you given him a copy?
No, I have not seen one.
You give him a copy, you have a look at it because I think your grievance is addressed. You are seeking for what? For
Regular pension, lordship.
pension.
Yes.
Yes, it says that
So it was submitted, the proposal for regular pension is submitted before the Director of Pension on 16/7/2024. Now it is the Director of Pension, lordship. They will see what about the.
for pension. Yes, Mr. Pegu, what is the status?
I'll have to get the instruction, my lord.
No, why is it that you are not having the instruction today when the matter is called? It's ultimately a
Earlier we
matter
was not-
relating to pension.
We are not aware whether the proposal was sent by the petitioner. Only today
No,
we have come to know.
what is your officers doing? They are not guiding you. Are they not aware that the matter is listed today? Pension matters should not be treated so casually. One day the matter will be fixed for producing instruction, then some instructions will come saying proposal has sent, then another date to see what has happened to the proposal. Why this? Because ultimately you all are government. The departments may be different, but when matters are listed before the court, some endeavor should be made on behalf of the government councils to find out what is happening, especially in matters like pension and all. These persons are waiting to get their pension.
Short rate, my lord.
Monday or Tuesday.
Wednesday, my lord.
Mr. R.K. Mushari, Learned Standing Counsel, BTC, pursuant to the order dated 3/4/2025, has submitted a letter dated 23/4/2025, received from the District Elementary Education Officer, Baksa, wherefrom it appears that the proposal wherefrom it appears that the provisional pension in respect of the petitioner was sanctioned and disbursed. Wherefrom it appears inter alia, that the proposal for regular pension to the petitioner has already been submitted to the Director of Pension, Assam Housefed Complex, Dispur, Guwahati 6, through the Director of Education, BTC, Kokrajhar, VD letter dated 27/6/2024 and Directorate letter dated 16/7/2024. Stop. However, despite the aforesaid letters having been submitted way back in the month of June and July 2024, comma, Mr. G. Pegu, learned additional senior government advocate for the state representing the pension department, does not have the requisite information as regards the status of the said proposal. He accordingly seeks a short accommodation to place the status of the aforesaid proposal before this court on the next date of listing. Prayer is allowed. List on such and such date. It is needless to be clarified that by the next date of listing, Mr. So-and-so shall positively inform the court as regards the status of the aforesaid proposal.
Obliged.
Yes, Mr. Sharma, anything?
Item number 9, my lord, there's an interim order that needs to be continued.
Interim, if any, shall continue till the next date of listing.
Item number 11.
Lordship, here in this case, Lordship, the para was comment received, Lordship. I will file an affidavit, Lordship.
Well, kindly have a look at the last order. When
Yeah,
they were
regarding
directed to
record.
produce the records. madam.
Yes, Lordship, first, let me file the affidavit.
As prayed for by Mr. J.K. Goswami, and additional senior government advocate, list this matter. How much time? 2 weeks? List this matter after 2 weeks on a date to be fixed by the registry to enable the state respondent file their return in the matter. It is needless to be clarified, since Mr. So-and-so has submitted that the parawise comments have been received in the matter, the return shall be positively filed by the next date of listing.
Item number 28.
Yes, Mr. Manan, Mr. Kaushik,
Yes, that.
you got it?
The judgment, I think what your lordship indicated was with regard to the paragraph that was given, I think there in Vihan Kumar itself,
Okay.
where it says that no restrictions will be considered in a bail application when the Article 21 or 22 is violated.
All right.
That paragraph, I'll just refer.
Yes.
Just a moment. Vihan Kumar, paragraph to move light is. That is 21F.
1 second.
Yes.
Of Vihan Kumar.
Yes, there is a on 21F, that is in the conclusion part of the judgment.
You are holding a printout of the Supreme today or 20?
This is para 21 in this. There are
21F, yes, yes, yes,
Yes.
I've got it.
F.
Yes.
It is there.
Yes.
When a violation of Article 22(1) is established, it is the duty of the court to forfeit order the release of the accused. That will be a ground to grant bail even if statutory restrictions on the grant of bail exist. The
All right.
statutory restrictions do not affect the power of the court to grant bail when the violation of Article 21. That your lordship pinpointed
All right.
yesterday. That's
All right. Yes, Mr. Kaushik.
So far, first, I'd like to reply to this point, number 21F. This point is applicable to the statute, like my NDPS cases, where there is a statutory bar, like section 37 of PMLA or UAPA Act. This particular proposition 21F deals with those kind of
Followed,
section,
Mr. Kaushik.
those are
Hmm.
specific method. There is bar method. And this is like a subsequent bail application, not subsequent third time. And these law,
So if a bail is, if a subsequent bail application is filed,
yes,
where in the first two rounds they have not taken the ground of illegal arrest,
yes,
and for the first time it is taken in a subsequent bail application, the arrest, if it appears to be in violation of Article 22(1) of the Constitution of India, would that make that arrest legal?
I don't why, because here this law is there before his arrest. He knew that law.
That is
But
all
yes,
right. You
yes.
see, Mr. Kaushik, whether the petitioner knows, the petitioner doesn't know the law, that is not the question here. The question is much more than that. It is the very fundamental right of the petitioner which is now in question. He has a fundamental and a constitutional right to know the grounds of arrest. You may be right that it was seized from his possession. That is not sufficient to discharge the burden from you to inform him that because these contraband articles which have been seized from him are contraband articles, are articles which are prohibited under so and so, and therefore a case is made out for which he will be arrested. This is what you need to inform him in a language he will understand.
Yes.
This is the basic thing which you need to do.
I know here.
Now, if that is not done at any point of time, if this issue comes up, this court has to protect him. Are you following what this
So
court
I
is saying?
My humble submission
Yes.
is that my lord, since it was there since long, my he knew that my lord, plus first two occasions, my lord, he did not do that. point, my lord,
Repeating
because-
will not help.
Yes,
I
my
have
lord.
indicated
Yes,
the
my
mind
lord,
of the
that is
court.
there.
You
And
want to say something else, please do.
My lord, and regarding.
I'm
my
giving
lord,
you a patient hearing.
Yes, ma'am. Regarding because the Bihan Kumar, but prior to Bihan Kumar, there has to be professor. And prior to that, my lord, Focus Bangsa. And prior to that, my lord, long before there was my lord, Himayat case in 1968 regarding Article 22(1). Here, what has happened, my lord, in Provin Bansal, your prosecutor knows, my lord, there the question was in PMLA Act. And there the person were not caught rated. In Provin Purkaisto also, the person was not caught rated. In Bihan Kumar also, the person was not caught rated.
But there are coordinate benches judgment of this court where
Yes, my lord. In
it
fact,
has been seized from the
yes,
possession
but,
of the
yes,
person.
my lord. My point is that, my lord,
You see, possession is immaterial. Is immaterial. That person may be a layman. He may not know. He may not know that carrying this particular thing is an offense. Now, we cannot presume that he will know. He may not know.
allow me,
Now, you see, these are things, if we start accepting a submission like this, it is going to create havoc.
my lord, in fact,
The basic constitutional rights will get frustrated.
my lord, in fact, day before yesterday, in this matter, a similar situation, the Honorable Supreme Court is dealing with a similar kind of situation where the person has been caught red-handed. And that petition, the Supreme Court has reserved its judgment, my lord, regarding those Bombay worldly.
But no judgment has come today.
My lord, but I
Any judgment of the
So, my
apex
lord,
court
day before
as on
yesterday,
take?
they have reserved.
You please say that. Don't
Yes.
make such submissions.
So, my
If there is a judgment of the apex court as on date, please give it.
so, my lord,
Now, if something is reserved, please don't make such submissions.
yes, ma'am. No, I'm saying this thing, my lord, because this question was raised also.
If a judgment of the apex
No,
court
that
is
is
there,
not-
kindly give it to the court.
That has not-
If it is not there, then don't make unnecessary submissions before the court.
Yes.
Please be mindful of the submissions that you make before a constitutional court.
And second thing is that, my lord, here the question of rate and that issue initially came up, my lord, in my lord's judgment of my lord Christie versus Ministry. That was because in that case, initially, the first time, the question of illegal arrest was came up and there certain propositions were framed. And that judgment, my lord, one proposition was held that if a person got red-handed, and it was specific, and I would like to rely on the judgment.
Yes.
Page 572.
This is of House of Lords.
Yes.
Yes,
Page 572.
570.
2.
2.
Yes.
Yes,
Below portion, my lord.
yes,
There are 4 propositions, my lord. 1, 2, and 3, and 4.
yes, yes,
We are concerned with 3.
yes,
Shall I read it, my lord?
yes, please.
The requirement that a person arrested should be informed of the reason why he is seized naturally does not exist if the circumstances are such that he must know the general nature of the alleged offense of for which he is detained. Then, my lord, kindly come to page 575.
In what context this has been said?
Here, a person was arrested, madam. Here that person was not given any grounds of arrest, and that issue was first time raised here, madam. Then this court, framed certain proposition. Then this proposition came. They said ultimately.
What is the constitutional right involved in England?
Madam?
What is the fundamental constitutional right?
Same, madam. They have to.
Where is it?
Madam, this is the first time they have raised this issue in this case.
No, in this case, where do I get that?
Madam, this proposition, madam.
This is the citations and others which are referred by the Lord seems to me to establish the following proposition. This is the proposition.
Then,
But I am asking what is the fundamental right? Page 57? Yeah. Yes, placetum G.
Yes, madam.
Yes.
Then this again, I think it is clear that there is no need for constable to explain the reason for arrest if the arrested man is caught red-handed and the prelude to arrest where it is important to secure possibly violent criminal. Nor again can it be wrongful to arrest the detained man on charge of which he is reasonably suspected with a view to further investigation of a second charge, which information is complete. In all such matter, wide measure of discretion must be left to safety of the preserve the peace and criminal justice. Then
Yes.
This these are these proposition again, my lord, was accepted in my lord in the case of my lord Madhu Nimai and others in our honorable Supreme Court.
But Mr. Kaushik, you are not answering the question that this court is asking.
Yes.
What is the constitutional position?
Yes.
And before at England at that time? Is there a similar provision like Article 22(1)?
At the time.
Yes.
From this judgment, I have not come to.
So that is what is, you see, a judgment is contextual.
Yes, madam.
You cannot simply pull up the proposition and rely. It has to be understood in the context it is delivered, right?
Yes.
Now, here is a situation where there is a constitutional right in favor of the arrestee.
Yes.
Are you following what I am saying? It is not just a statutory right.
Yes.
The right flows from the Constitution. Correct. Now, whether that can be ignored merely because the investigating officer thinks that, well, he knows. Well, he knows. Is that sufficient?
That's why
No, I understand where you are heading. I appreciate the midnight oil that you must have burned since yesterday. But you see, this proposition has to fit in the circumstances of your case.
Yes.
So for that, you have to show what is the law.
Why I have gone through this judgment to go to this judgment of our honorable Supreme Court. Madhu Nimai case, this is one of the first cases in India. Here, although Madhu Nimai is a political leader, that case, although he was not caught red-handed, ultimately.
Not caught red-handed.
Not red-handed, but here also, Supreme Court said that my lord, grounds of arrest has to be given to him. My lord. But the thing is that here also Supreme Court observed and gone through the proposition of this case. I have already referred to.
But how does it help?
No, my lord, why
How does it help you, Mr. Kaushik?
no, my lord, I'm reading through the paragraph.
Because
of the-
first of all, in this case, he was not caught red-handed, and the apex court have said that yes, ground of arrest must be given.
Yes,
Yes, then
so I kindly, my lord, come to page 161.
page
161.
161.
Yes.
Yes.
F, my lord.
F, placitum F.
Yes.
Yes.
My lord, here this proposition was referred to show that this proposition was.
Read.
Yes, my lord. Article 22(1) embodies a rule which has always been regarded as a vital and fundamental safeguarding personal liberty in all legal systems where the rule of law prevails. For example, 6th Amendment to the Constitution of United States of America contains similar provision, and so does Article 34 of the Japanese Constitution. In England, whenever an arrest is made without warrant, the arrested person has the right to inform not only that he is being arrested, but also of the reason of grounds for the arrest.
But here it doesn't refer whether
Yes,
it's a
no, no, I'm just
constitutional
saying-
right or not.
Yes, madam. The House-
Unlike United States, the 6th Amendment,
Yes, madam.
and in Japan also, the
Constitution.
Article 34
34.
of the Japanese Constitution.
No, my point is not that, madam. The House of Lords.
But that is the very point that this court is asking you, Mr. Kaushik.
No, I'm coming to that. I'm
Yes.
just answering one by one so that you can help me. The House of Lords and Christie was another and so. When did the origin and development of this rule? The rule was developed in this case. In the words of Wisconsin, if a policeman who entertained a reasonable suspicion that acts had committed felony were at liberty to arrest him and march him off the police station without giving any explanation of why he was doing this, the primary right of personal liberty would be gravely infringed. Wisconsin laid down several propositions which were not meant to be exhaustive. For our purpose, we may refer the first and third. The first one, where it is expressed there, my lord, it has to be given. And the third one, I have already my lord, pointed out in the earlier judgment. Lord Simon gave an illustration of the circumstances where the accused must know why he is being arrested. There is no need to explain reasons in the below portion D, my lord. Reasons of arrest if the arrested man is caught red-handed and the crime is patent to high event. This observation, this citation relied on, my lord, but subsequently, since it was not argued before that court. my lord,
This is not, please be mindful what you're saying.
Yes.
The court is only quoting those propositions. Now,
Quoting
what
them,
does
quoting.
the court say? Let us see that.
Yes, no,
Has
but-
the court said that there is no need to explain
no, my lord,
under the Indian Constitution? Is that there?
my lord, kindly come to 163. my lord.
Yes.
My lord, F portion, my lord,
Yes.
8 line from below, my lord.
It has not been contended
Yes,
on
not
behalf
on
of the
behalf
state that the
circumstances
circumstances were such that the arrested person must have known the general nature of the alleged offense for which they have been arrested
Yes, my lord, that was-
by proposition number 3 in so and so, nor has it been suggested that the so-called notices which were so and so are therefore entitled to be released on the ground on this ground alone. Once it is shown that the arrests made by the police officers were illegal, it was necessary for the state to establish that at the stage of remand, the magistrate directed detention in jail custody so and so.
Yes.
Nothing has been held.
Here it is said that, my lord, since it was not argued, my lord, before that court.
That is why I'm
Yes.
saying. So when that is not applicable, that situation is not applicable, the courts have not held it in context of an Indian constitution. You want this court to now rely on, ignore all the Indian law laid down by the apex court and rely on a decision of the courts of England, where you are not even showing me what is the position of the constitution.
But that provision, perhaps,
Then-
I have to look into. And second thing, well, I would like to point out one judgment for Allahabad.
This court is not bound by
Yes, sir, not bound,
decisions of another high court.
but it has persuasive value.
Of course, it has persuasive. Yes.
Kindly come to page 5. Here, what has happened, the one judicial magistrate was beaten by the lawyer. And he was arrested subsequently. He took this plea that grounds of arrest were not provided to him. Then we kindly come to page para 5, my lord.
The same decision has been relied.
Relied, my lord, para 6. Shall I read, my lord?
Yeah.
From para 5, 6, I am reading, my lord.
Read para 6. Para 5, I think, is of
No,
that decision
of Limaya and
of Simon,
Simon.
Justice Simon. Yes,
And Limaya also.
yes.
It is apparent from this observation that what is important is that a person concerned must be fully aware of the reasons for his detention. Not really as to how these reasons have come to his knowledge, as has been explained in observation in Islam Simon. There is no need to explain red-handed and crime is patent.
Where did you read the word red? There is
Why
no
not
need
this
to explain handed.
actually.
Huh?
There is no need to explain handed. It should be have been.
No, but red is not mentioned.
Anyway, my lord, next paragraph I'm reading.
Why are you reading the word
No, my
red?
lord, this is
It's a quoted portion.
portion.
Yeah.
Quoted portion. In other words, according to this observation, if a person is apprehended at the spot while committing the crime, he must be deemed to be in the know of the reason for his detention and failure of the concerned authorities. To inform him of these reasons separately will not at all be material and will not adversely affect the legality of his detention. In Mustaq Ahmed versus State of UP, next paragraph. Can I read?
Yes.
In Mustaq Ahmed versus State of UP, 1984, so and so, the appellant was caught red-handed by the complainant and others at the time of occurrence and was taken to the police station where the complainant lodged a report of occurrence and handed over the applicant to the police. It was contended on behalf of the applicant that the detention of the applicant was illegal and he was entitled to bail. The decision of Bimal Kishore, the state of UP so-and-so, Madhu Nimai and Ram Chapra so-and-so were cited before the learned judge in support of this submission. On the facts of the case, the learned judge revealed the contention and held. In this case, the appellant was caught red-handed by the complainant and others at the time of occurrence and was taken to police station where the complainant lodged a report of the occurrence and handed over the applicant to the police. In these circumstances, it cannot be accepted that the applicant was not informed of the particulars of the offense for which he was arrested. The observation.
One second. Yes.
Paragraph 8, madam. The observation made by the learned single judge in Mustaq Ahmed case so would appeal to be fully sustainable in view of the decision of the Honorable Supreme Court in the matter of Madhu Nimai, which I referred to, particularly the observation endorsed and reiterated by the apex court as indicated above. Therefore, with respect, I fully subscribe to the view taken by the learned single judge in Mustaq Ahmed versus State of UP. Paragraph 9. Accordingly, it must be held that if an accused is apprehended at the spot while committing the crime, handed over to police and detained, the detention cannot be
Challenged.
On the ground that provisions of Article 22 of the Constitution or Section 50 of Code of Criminal Procedure, which is now Section 47 of BNSS, have not been complied with. As it obvious from the observation of endorsed and repeated by the Honorable Supreme Court, the requirement that a person arrested should be informed of the reason why he is seized does not exist. If the circumstances are such that he must know that
is referred is this one, right?
yes.
Endorsed
and repeated by the requirement that a person arrested.
Only, see, I think Mr. Kaushik, you need to show this for the position, the constitutional position of England at that time, because that the apex court decision, with utmost respect, I have reservation to agree with this particular finding that has endorsed that. It has merely because in that situation, that thing did not exist. So there is no endorsement. It was referred. Referring doesn't mean an endorsement. There is no discussion on that, right? In the context of the Indian Constitution, right? Now, it only in that decision, in the English decision,
Yes.
what is referred is about the American Sixth Amendment Constitution as well as the Japanese Constitution. But it doesn't say the Constitution of England. It merely says in England, this is the position. So it is not clear. You can clarify that. I'm sure you don't have it today, so we can have this matter on Monday or tomorrow. But
My lord.
you clarify that position.
My lord, why I'm referring this decision?
I have understood.
Yes, because here that point has been clarified, Article 22 will not
No,
come.
where in the, but you see this,
Yes.
this is not a binding decision,
yes,
right?
right.
Now, in order for this court to be persuaded with this decision, or to share the same perception, there has to be something more. Otherwise, I share the perception held by the coordinate benches of this court in situations where it has been seized. Of course, the argument which you are making today before this court was not made in those.
Yes. So my
So therefore, I am saying that you look into that respect, and if you have something more, you bring it. Otherwise, you have placed your point.
Madam, there is another point, because my argument is that madam, these issues, because while dealing Praveen Bansal, Praveen Purkaiska and Bihan Kumar, these points were not raised before the Honorable Supreme Court.
But you see, this court has its own limitation.
Yes.
This court cannot now interpret those decisions. It has been clearly held that any violation, statutory prohibitions will not come in the way. It is very clear. Right.
Another
Now, as I have said, that mere fact that a person is caught with some contraband articles, according to me, is not sufficient for him to be to deem that he knew that that is an offense.
another point
Otherwise, it will create a lot of problem. That is the thing which is going on in the mind of this court. So you show me that what is the position of the Constitution, England Constitution at that time. Yes, what do you want to
another
say?
point I would like to make, madam, here, because initially that was propagated from Praveen Bansal. In subsequently of the Honorable Supreme Court judgment, madam, Ramkishore Arora. Madam, here this Ramkishore Arora, it has been clarified that, and subsequently there are other judgment of Honorable Division Benches of different High Court. Madam, here it has been clarified that the Praveen Bansal judgment will be applicable prospective.
Does not?
Will be applicable prospective.
Will be applicable?
Prospective. That means from the date of judgment of the Praveen Bansal. Here, the petitioner was arrested in this particular case, madam, prior to the judgment of Praveen Bansal. And this is the Supreme Court judgment. I'm relying.
Yep.
There are 23 last portion.
Para?
23 last portion.
Yes.
Sorry, Praveen, not Pankaj Bansal. As discernible from the judgment in Pankaj Bansal case, also noticing the inconsistent practice being followed by the officers arresting the person under Section 19 DMLA, directed to furnish the grounds of arrest in writing as matter of course, henceforth, meaning thereby from the date of pronouncement of judgment, the very use of word henceforth implied that the said requirement furnishing grounds of arrest in writing to the arrested person as soon as after his arrest was not mandatory or obligatory in the date of the said judgment. The submission of the learned senior counsel, Mr. Singhi, for the appellant, that the said judgment was required to be given effect retrospectively, cannot be accepted. When the judgment itself states that it would be necessary henceforth that the copy of such written grounds of arrest is furnished an arrested person as a matter of course without exception. Hence, non-furnishing of grounds of arrest in writing till date of pronouncement of judgment of Pankaj Bansal, same in writing could be faulted with. As such, the action of informing the person arrested about the grounds of his arrest is sufficient complies Section 19 so and so
That is as regards the written grounds, but nowhere in your materials indicates that even verbally it was explained, the grounds.
Case ID has to be.
No, no, it is there.
So-
It is already there, the scanned copy.
In fact, Praveen Bansal has been discussed in the Vihan judgment itself. It has elaborately discussed this.
Behind judgment, I think Justice Singh.
Justice Singh has subsequently given
Subsequently,
yes, another part where it was more specific.
correct.
And then your lordship, with regard to my learned,
See, the owner, Mr. Kaushik, you have to, as far as that aspect, yes, to an extent, you have moved the mind of this court, but you have to show something more. Otherwise, I'm not with you. But this aspect, Justice Singh's portion of that judgment is very clear that you have the onus lies on you, the investigating officer. When a point is taken that he was not informed, then the onus lies on the IO to show that it was informed. How it was informed, nothing is there here.
I just want to raise a point here because here the court held that, and subsequently there are other judgment I placed on Monday, my lord. Here the honorable division benches of different court, my lord. There, my lord, relying on this Aurora judgment, my lord, they have specified that after the judgment of the Provincial Council, it means the Provincial Council judgment on the date.
That point you have made and this court has noted.
Yes.
There is no need to multiply authorities on that point. All right, Provincial will apply prospective. That you have made it.
That has been discussed, but Provincial, there was the issue because on the date of arrest, the judgment was uploaded. This argument was made in
With Mr. Kaushik now, Article 22(1) is clear?
It's clear.
Is clear? Correct? Then
It's clear, but my.
any violation, do this court need to look into any decision? That itself is clear. It makes no interpretation. It needs no case laws for ascertaining that right which is available. This is his constitutional right. If the court comes to a finding that this right has been violated,
That is true.
this court can always release the arrestee. He cannot be kept confined when it is apparent that his constitutional safeguards, constitutional rights have been violated. That is all.
That is there, madam.
That is all.
My point is.
So no need to multiply more authorities on this point.
Yes, sir. I only saying that, madam, is Bihan Kumar, Provincial Professor.
I've understood. Repeating will not improve your case. I have noted your submission on this. Yes.
Because Bihan Kumar judgment has been passed based on Provincial Council.
All right, noted.
And Monday when I will place.
Yes, Mr. Manan, anything or you will reserve your reply till
Lordship,
Mr. Kaushik
I don't
completes?
think further reply I'll make. Just one thing I'll just point out. My case was basically, your lordship, the factual part. I've given I think a copy of.
Your case also has another issue because
Yes, there are three. Actually, that is
2
what I'm
years,
trying to point out. There are three issues. One is even, another one is that Article 21 issue, where is a long inculpation.
correct. That is 2 years. How much time?
2 years, more than 2 years, about.
And out of
Today,
19,
I'll have to.
out of 19 witnesses, 6 witnesses.
Only 6 witnesses. That part is also there.
7 witnesses.
That
And
part
these 7 witnesses have not
not
referred.
implicated.
have
These
not
parts were
implicated.
also there, your lord. And one more important part was that he was not caught red-handed. He was sleeping in a house. This person, the police went there, and ultimately the person took the police to a particular, I think, school which was not running. And from the pond near the school, the FIR, your lordship, is there. From the pond near the school, a drum was recovered, a blue color water drum, and from the drum, 22.2 kgs of ganja was recovered, and the weight was done along with the drum. And I had also that point, whether these weighting together, which will make it as a commercial, but if it is separately weighted, the matter may not be even commercial quantity, that nobody knows what is the quantity. That was one question that was raised in the very first occasion. Later on, this Vihan Kumar and all came. That is true, your lordship. There was, I in fact gave a
Yes,
gist of that. Mhm.
I have read it.
And in fact, on the grounds of, on the other three grounds, I have given some citations.
You are Ajibur Rahman.
Ajibur. There were three persons arrested, Your Lordship. The second person was, I think, I must look at it. Aradhan Burman. He was already, Your Lordship, discharged by the court. The only this person remained. And here, Your Lordship, in his case, it was 22.2 grams. That was along with the ganja, along with the dram. And that was not recovered from his person. It was recovered from a particular place where he was led. The police, he led the police to that place from where it was
Yes,
recovered.
you're right.
So that cannot be said, you know, so in a
And,
different context.
He was found in a,
Hut. He was sleeping in a hut.
in an abandoned washroom.
It was found, I think, of a abandoned washroom or school. I think.
Abandoned washroom.
Yes.
And asking him about the ganja, he leaded the team where
Yes.
he concealed the drum.
That is the fact of the case. Not, it is not that it has been recovered from his person. Red-handed. That is why I'm just pointing it out. That is
All
the-
right.
That's all.
Cigarette is sold, is from him and he sold them in here.
Tomorrow. Tomorrow. Relist tomorrow at 2. Only on that point. I have heard you extensively, Mr. Kaushik. Just show me what is the position. That's it. Otherwise, I have heard you at length.
Regarding these two aspects, following incarceration and regarding wages of this contracting, then also I'd like to reply.
Tomorrow.
Much.
Our orders, item number 12.
May I please your lordship? Learned counsel, Mr. A.R. Bhuya is unwell. Lordship may kindly take up the matter.
12.
Yes,
Why is this matter for orders?
in fact, lordship, the respondent number 1, the content number 1, he has already been expert and he has already been lordship, and the respondent 2 is the main person who is to comply with this order. That's the lordship may kindly print the last order dated 4/4/2025.
So, the only issue is whether the order of the of this court is complied or not.
Yes.
So it is complied.
Yes, it is, and it is already been complied, and the respondent 1 has already filed an affidavit long back on 3/1/2018.
Yes. Where is that affidavit?
3/1/2018 lawsuit. It is there.
What is it? 92.
The final 2018 long back.
Yes, affidavit by one.
One, Sandeep Mahia.
Yes,
He
which
was the
para?
then director.
Which para?
of the pair 4 of the mechanical period. That the deponent stated on receipt of honorable court's order dated 8/6/2017, as he has taken steps for compliance and peruse the relevant case records. In this regard, the directorate by letter dated 27/6/2017 instructed the district elementary education official Nagaon to take necessary action to comply with the honorable court's order in coordination with the school authority as the matter is related to the adventure stage. The DO Nogam Bharti letter dated 4/7/2017 informed the director that the school authorities, Respondents 5 and 6, had reinstated the petitioner in service and allowed her to perform her duties as second agent teacher with effect from 01/07/2017 by the order dated 4/7/17. Then locally candidate 5 wins.
All right, since he's short for time,
Yes, yes.
uh, as prayed for by Mr.
AR Bhuyan,
A.R. No, your name.
M. Ali.
M. Ali, learned counsel for the petitioner on the ground that the conducting counsel, Mr. A.R. Bhuyan,
AR,
is indisposed. Indisposed.
yes.
Is indisposed today. Relist this matter after 2 weeks on a date to be fixed by the registry.
Item 13 lawsuit on last order lawsuit honorable directed me to file an affidavit lawsuit on behalf of the respondent 4. So I filed it during the course of the day. So it is not in the record, I think. I have served a copy to the.
You received?
We have been served by, my lord, this is a matter where an order passed in 2017 has not been complied with fully till today. And your worship will go through the orders passed. They have been taking this plea or the other. In fact, my lord, in this
So, well, an affidavit is filed today.
affidavit has been filed.
So
and-
I'll have it fixed on Tuesday, Wednesday.
My lord,
Let that affidavit be on record.
because my lord, unless my lord, the personal
All-
evidence is
But
direct-
the affidavit has to be on record, Mr. Chaudhary.
True, true, my lord.
It is
Let
not
it
that
come
we
on.
deliberately.
All right, all right. So heard Mr. M.K. Chaudhary, learned senior counsel, assisted by
M. Datta.
Mr. M. Datta, learned counsel for the petitioner. Stop. Also heard Mr. S.M.T. Chesty, learned counsel for the department. Stop. Mrs. So-and-so submits that an affidavit in opposition has been filed today. However, the same is not available on record.
By respondent 4.
On behalf of respondent number 4. Let registry verify and place the same on record. Relist when? Wednesday? On such and such date.
Obviously.
Number 14.
Item number 14 lawsuit. Item number 14. The leave encashment and other benefit the petitioner has already received. And so as family pension is concerned lawsuit, a hearing has been scheduled on 29th of April to clarify some factual aspect. So let it come after 2 weeks lawsuit. I've given a copy to.
Mr. S.M.T. Chesty, learned counsel for appearing for respondent, for the respondent. For the respondent submits that the leave encashment and
Lawsuit other.
anyway, as prayed for by so and
Yes,
so.
lawsuit.
Is just enough to deliver. Release the matter on after 2 weeks. After 2 weeks? After 2 weeks on a date to be fixed by the registry to enable the to enable the respondent place necessary instruction to file necessary affidavit in the matter.
This item number 29.
As per the Lojama court order, my lord, I have to take steps on respond number
3, 4, 5.
that will start, my lord.
Instructions to appear for 3 to 6, my lord. I need some time to file the power.
3 to 6.
3 to
And
6.
who still remains unserved?
6 remains answered.
Six remains-
You are for 3 to?
6.
So you are appearing for 6?
Yes, 3 to 6.
So then service is completed. Heard, Mr. Your name?
D. Purkast.
P. Purkasta, learned counsel appearing for the petitioner. Also heard Mr. A. Das,
3
for
to 6.
learned counsel appearing for respondent numbers 3 to 6.
6.
And for 1 and 2, Mr. S. Bhuyan, learned counsel appearing for
1 and 2.
respondent number 1 and 2. Eto agot dibo, A das to pisot dibo. In view of, it appears that service in respect of all the respondents stands complete in view of the aforesaid appearances made by the learned counsels. Stop. Mr. A. Das, learned counsel for so and so seeks 3 weeks,
2 weeks time.
2 weeks time to file return in the matter. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
File the power of the wakalat.
Ah,
The wakalat nama.
You need a direction from this court?
No, my lord, I have not filed it, my
You
lord.
file it. I'll come back in 5 minutes.
Lordship, extreme apology in this matter, Lordship. Though Lordship, on the last date, Lordship stated for this matter to be listed after a week, Lordship, and this matter was fixed on 24th today, Lordship. But however, Lordship, we have noted the wrong date, Lordship, as
Sorry?
24/5. We have noted the date wrongly as 24/5, Lordship. So I'm praying for 1 week's further time, Lordship. We will file, Lordship, the compilation as per the order dated 25/6.
Chaudhary,
Milord, actually, Milord, there is a recent judgment of the Supreme Court, according to which, Milord, actually they are supposed to make submission regarding the cabinet memorandum.
yes.
Now, Milord, in view of the latest judgment of the 5 Constitution Bench judgment, since the advertisement is prior to the adoption of the UGC regulations, therefore, Milord, it will the old rule will govern. Therefore, net slate is not required. Can I place that latest judgment? Yes. I think on last occasion it was given, Milord. Case Prakash Pathak. Has your lordships got it? Milord? Case Prakash Pathak. It was unreported.
Unreported.
Yes. You can hand over one copy, Milord.
No, if it is there, otherwise it becomes duplication. I don't think, oh, yes, I've got it.
Ah. Please come to para 42, Milord. The conclusion. We therefore
40?
para 42, Milord. Last two
Yes,
pages.
yes.
We therefore answer the reference in the following terms. Recruitment process commences from the issuance of the advertisement, calling for applications and ending with filling up vacancies. Eligibility criteria for being placed in the select list, notified at the commencement of the recruitment process, cannot be changed midway through the recruitment process unless the extent rule so permits, or advertisement which is not contrary to the extent rule so permit. If such a change is permissible under the extent rules of the advertisement, the change would have to meet the requirement of Article 14 of the Constitution of India and satisfy the test of non-arbitrariness. The decision in K. Manjusri lays down a good law and is not in conflict with so and so, so and so. So, my lord, in the present case, the advertisement is of 24/12/1998.
Have you given any short note? You have given. Right?
Yes, my lord, we have given a written argument also, my lord.
It's given. Yes,
On-
Mr. Upadhyay, right? Upamanu, sorry. Mr. Upamanu, by when can you have the compilation?
Lordship, by 1 week, Lordship, after a week, Lordship.
You have taken already a lot of time.
Yes, Lordship.
It was last posted on 8th of April. Monday,
Yes,
you have the weekend.
Lordship, can it be on Wednesday?
Okay. My lord, only kindly mark
Wednesday
2
or
days.
Friday, you decide.
Friday.
Because it has to be positively there.
Yes, Friday.
Mr. Chaudhary, on Friday,
Yes.
let them give it. And if they don't give it by Friday, I'll close it.
My lord.
As
And
per-
our written argument is already there
Yes,
with
I
the
have
list
seen.
of dates.
I have seen.
Yes.
As prayed for by Mr. D. Upamanyu, right?
Yes, Lordship.
D. Upamanyu, learned, you're a standing counsel?
Yes, Lordship.
Learned standing counsel, Higher Education Department, list this matter on Friday date to debo on such and such date to enable the Education Department submit the compilation as sought for by this court earlier. Stop. List accordingly. Offer the hearing. Huh?
It is matter about I was directed to obtain records, but I have received record just now, my lord. I will have to go through it to assist the group. I have better maybe fees for another.
When?
My senior friends.
My lord, it's a very long pending case. I don't have any objection to his.
Let him go through the records next week, Thursday,
My lord.
or any other date. Please tell me, Mr. Borpatra, go ahead.
My lord, the lordship is proposing that we are comfortable. We'll be able.
Okay, Mr. T.C. Sutyal, learned additional senior government advocate, Assam, submits that he has received the records as called for and seeks a short accommodation to go through the same in order to assist this court. Stop. Prayer is not opposed by Mr. R.C. Borpatra Gohai, learned senior counsel assisted by Mr. R.D. Fukan. Relist Thursday? Next Thursday? Released on such and such date.
Next Thursday, my lord.
That will be 1st May, 1st of May. Must.
Item 17.
Obligation.
Yes, Mr. Saikya?
My lord, the petitioner.
Senior start, my lord. We have misplaced, unfortunately, we have misplaced our file, my lord. If my lord permit me sometime, then I will construct the file and I will argue. Otherwise, also, my lord, in this petition, the petitioner is seeking provincialization under 2011 Act that has already been struck down, my lord. In the meantime, their services has been provincialized under.
Mr. Saikya, you give a copy to them, let them reconstruct their file. In the meantime, it's a 14 matter. It happens sometime, right?
They are working as a people, my lord.
You want the matter to be heard?
No.
Heard Mr. R.C. Saikya, learned senior counsel assisted by MS? R. Bharali. R. Bharali. Also heard Mr.
S. Das, my lord.
S. Das, learned counsel appearing for respondent number
Higher Education Department.
for standing counsel. Learned standing counsel, higher education. And Mr. S.K. Mukhtar, learned counsel appearing for respondent number 6. Mr. So-and-so, learned standing counsel, higher education, submits that since the matter pertains to the year 2014, comma, the concern, the brief of the case has been misplaced by the office and seeks accommodation in order to reconstruct the record of the case. Stop. Prayer is allowed. Relist when?
After 3 weeks, my lord.
Should not at the date on such and such date. In the meantime, your name? MS R. Bharali shall furnish a copy of the pleadings to so and so, so as to so and so. You give him, it will be easier.
Much of it.
Item number 20.
May I please your lordship? Your lordship, my senior is suffering from illness, so he's unable to appear
Huh?
today.
Your
My
senior
senior
is
is suffering from illness, your lordship.
illness. You are there. Why don't you argue? You have the brief. What is it? Dismissal from service. What is the issue involved?
Your lordship, I'm unaware, your lordship.
Huh?
I'm unaware, your lordship. I am newly engaged.
You are?
Newly engaged, your lordship.
You're newly engaged. But you are engaged, no? And the matter is today fixed for hearing. If you don't grab opportunities, when will you start arguing? Huh?
Your lordship, may kindly adjourn for today, your lordship.
Let's join it today, but the next day you argue.
Your lordship.
Your name?
F. Shaheen, on behalf of another.
F.
Shaheen.
as prayed for by MSF signed learned counsel appearing for the petitioner on the list this matter after
Your Lordship, on first week of May.
first week on such and such date on such and such date so and so submits that. Who is your senior? Who is unwell? That Mr. N. And Bharali learned counsel appearing on behalf of the petitioner, learning conduct arguing counsel. So the petitioner is indisposed today and seeks accommodation in the matter. Prayer is not opposed. Relist on such and such date.
Number 21.
May I please your lordship? Lordship, the senior counsel is on legs in another court, lordship. Madam, we pass over for the time being.
Who is the senior counsel?
Lordship, M. Sarania.
Huh?
M. Sarania, lordship.
Mr. Das?
He's seeking time for the timing.
Yes.
May it please you, my lord.
Who is appearing for R5?
Mohanto is appearing.
Ms. Bhattacharya? Yes.
May it please you, my lord. The petitioner has passed his Master of Arts in English in the first class and also qualified in NET. The petitioner is also a JRF awardee conferred upon her by the University Grants Commission. But her claim for the post of a senior lecturer or assistant professor in the College of Regularization has been passed over unethically and wrongly by the selection board. As such, the petitioners moved this court for cancellation of the interview procedure, it being false. Pursuant to an advertisement dated 10th of October 2020, the petitioner applied for the post of Assistant Professor of English in Regularization College, Nagaon. The respondent number 5 has also applied for the same post without submitting the mark sheet and the PRC along with the application. Although the college authority ought to have rejected the said application in terms of the advertisement, but accepted the said incomplete application.
What is your grievance?
Grievance is, my lord, that the selection was held on 12/12/2021. There are 14 candidates altogether who appeared in the interview board. Out of those 14 candidates, the petitioner was the most competent and the best candidate of all these 14.
What right do you have?
My lord, may kindly refer to the terms of the advertisement appearing in page 19. The candidate, I'm referring to the main parts. The candidate have to acquire qualifications as on the last date for submitting the application.
One second, Mr. Chaudhary.
Please.
Yes, which page?
Page 19, my lord. The running page, huh?
Yes, advertisement, yes.
The advertisement appears
Yes.
issued by principal of the college.
No,
in
which
Assam.
is the relevant portion? What
Relevant portion is, my lord. The candidate have to acquire. It occurs towards the end of the first
Must have
paragraph.
permanent residential certificate.
No, my lord.
Then
Educational qualification.
Where is it there?
Then towards the end of the first paragraph.
Huh?
E. The applications are invited in prescribed format,
Yes.
complete biodata, and all testimonials from HLC onwards from the eligible candidates for filling up of the following sanctioned posts of assistant professors.
Yes.
Then we are concerned only with the third one, the English, the post of English or one unreserved point, unreserved post. The candidates have to acquire qualifications as on the last day for submitting the applications. Eligibility. The candidate must have permanent residential certificate, PRC. The applications with all relevant documents, along with non-refundable tuition debt, must reach the undersigned within 15 days.
What is that the respondent number 5 does not have according to you?
Please. Respondent number 5, my lord. Lordship may kindly refer to page 20, where their merit position have been unloaded. Page 20.
Yes.
Respondent appears on Moitri.co 18, serial 18.
Yes. Mark sheet not submitted.
Yes, my lord. PRC not submitted.
Huh?
PRC not submitted.
No, 18 against 18.
Again, 20, Bandana Sharma,
Oh,
who
yes,
was the
yes.
petitioner.
I've got it. No, it says no.
Yes.
PRC is not submitted.
And mark sheet,
Not submitted. PhD, no.
yes. She has secured altogether the total.
61.47.
Yes. And Bandana Sharma, occurring on serial 20.
That is the petitioner.
Yes, Bandana Sharma, the petitioner.
Everything is there.
Yes, 20th. She has
She's
secured.
got more marks.
Yes, 62.63.
Yes.
So claim of Bandana Sharma has been wrongly passed over. My lord.
So according to you, because the requisite criteria criterias have not been met.
Yes.
That is why the appointment of respondent number 5, right? 5 is
There are
bad.
other points also, my lord. I'm bringing to your lordship's notice one by one.
Yes.
All relevancies that have been taken place
Yes.
while the interview was being
So
conducted.
this is one. And
This is one. Then the respondent number 5 application was not complete. It was sort of, she did not file a number of marks she did not submitted. She did not submit also the PRC. So her application was not complete in terms of the advertisement, which itself ought to be rejected at the very threshold of the interview. Then, but the respondent number 5 has been selected in superstition of the petition. Now, in the PRC, yes. Subsequently, anyway, an application has been interpolated into the records of the college authority, stating that she would prefer to submit her application, her PRC in due course of time. That particular application doesn't bear any date, neither the endorsement nor authentication. That is interpolation, perhaps to regularize something that cannot be regularized. Then, respondent number 5 also at that relevant point of time did not submit her marks. When her marks were not submitted, how is it possible on the part of the college authority to give her weightage in respect to the marks that she was supposed to secure while she passed MA examination? She admitted that she failed to submit her certification mark sheets, but despite that, her weightage in respect to the marks she has been offered before in the evaluation. Over and above, despite that, her total assessment falls short by 2 marks. Then, respondent number 5, it is stated that respondent number 5 submitted some publications. Those publications were in fake journals, not in regular scopus or university accepted journals. So in fact, those over and above, if your lordship kindly refer to page 102, where she herself admitted that she has only sent her publications to be published in a journal, but not yet published. Despite that, the selection board has awarded her weightage in respect of publication, which she ought not to have done at all. Then, regarding net, in the net qualification in the net or state pass is an essential qualification in respect of any candidate to be selected for the post of assistant professor. Our candidate petitioner is not only was selected in net, not only she qualified in net, she also qualified net examination with JRF. JRF carries a weightage. JRF is allowed only when the successful net candidates occupy a position at the higher echelon, higher part. So, and JRF carries is class of 30,000 rupees a month. Over and above, one JRF awardee is not required to sit any test for pursuing PhD degree. But the respondent number 5, she failed to get any JRF. Despite that, she has been selected. And this candidate, Mr. Bandana Sharma, the petitioner, she had her publications, and it is admitted in page 118. It was admitted by principal that she has submitted her publications in university-reviewed, university-accepted journals, and she has not been, that her case is overlooked by the selection board while weightage has been given. And thus, wrongly and purposefully, a weightage of 2 marks has been added to that candidate, Mr. Dr., thereby superseding her claim for the post of Regularization College. So the selection being initiated, the obligation, the petitioner being aggrieved, she has filed a state petition, and the original order says the outcome of the post, continuation of her post in the same post would be subject to the outcome of the state petition. And that is our main defense, my lord. So she had her publications have been given in weightage. The candidate also and the respondent, her application was incomplete while she submitted it, and is mandatory on the part of the, and that also her incomplete application is accepted in lieu of a complete application of the petitioner. That is wrong. Erroneous.
Don't repeat.
Yes, my lord. No, sorry, I'm digressing a little bit.
No, it's all right. I noted. Anything else?
So these are she was JRF awardee. She has had this, and overall her publications. All these facts disqualify the respondent number 5 for being selected in lieu of the petitioner. This is the main submission for which, and this selection process should be cancelled altogether, my lord.
Yes. You are for the?
I'm for the college authorities, my lord, respondent number 3 and 4.
Yes. Why R5 was
the list which has been shown is not the comparative statement of marks. Lordship will kindly take up the affidavit of respondent number 3 and 4, my lord.
Mrs. Chaudhary, please take your seat. Yes.
The affidavit of respondent number 3 and 4, lordship, internal page 12.
3 and 4.
Yes. The college authorities, my lord, and the selection.
Yes.
But what has been annexed with the petition is the list of students who has applied, candidates who has applied in pursuance to the advertisement. That was not the comparative statement of marks. This is the comparative statement of marks. It says duly signed by all the members of the selection committee.
Yes.
Lordship will kindly see Moitri Deka, respondent number 5 is placed at serial number 12. She has got PRC, my lord.
Page.
Lordship, internal page 12, my lord, annexer 2. Page, running page 51.
Is it 51?
Lordship will
Oh,
kindly.
actually, sorry, I am holding the affidavit in reply. Affidavit in opposition.
Opposition of respondent number 3 and 4. my lord.
Ms. Bhattacharya, it starts at, okay, I've got it, 41. Starts at 41. You want me to go to page 51? Yes.
Lordship has got it, my lord. This is the comparative statement
No,
of marks.
page 51 is
Lordship will
internal
kindly
page
note internal
11.
page 12, my lord. Because
12. Yes.
At that time, there was no running page. there
52.
was 52. correct.
Yes.
Internal page 12.
Yes. Yes.
This is the comparative statement of marks of all the candidates who appeared in the selection.
PRC, yes.
Here, my lord, the respondent.
Select, no.
Net, yes, my lord.
Net is where? Yes.
Yes.
Net
Yeah.
is 2019.
Yes.
Yes.
So she has all the qualifications. In the mark sheet, what happened, my lord? While in the affidavit, the authorities have specifically
And
stated.
the mark is 63.47.
Yes, my lord, the petitioner is in the third position. Lordship will kindly see,
Yes, I've
as per
seen.
this comparative statement of marks, the respondent number 5 secured
More marks.
63.47.
More marks.
Second position is Bhumika Devi, which is at serial number 4, with total of 62.96.
Hmm.
Now, my lord, this Bhumika Devi is not being made a party in this writ proceeding.
Hmm.
Even if this writ petition is allowed, but it is Bhumika Devi who will get the appointment, my lord, not the petitioner, because she is otherwise in the third position.
Hmm.
And the submission is that PRC was not there. It was, my lord, not a correct statement, my lord. She filed an application, lord.
The document at page 20 is an unsigned document.
Yes, my lord. That is what happened, my lord. All those,
An unsigned document.
in order to bring transparency in the process, those who have all have submitted their applications, that was uploaded only to bring transparency. Nothing else, my lord. That is not the comparative statement of marks. What has been annexed, my lord, as annexer 2 in the affidavit of respondent number college authorities, that is the comparative statement of marks.
So this document 20, you are not otherwise disputing. You are saying this was only uploaded.
Only preliminary for the purpose of.
Where have you stated so?
No, my lord, I am stating, my lord, that this is the comparative statement of.
I understand, but you see now there are two statements before this court, right?
Yes.
One annexed by the petitioner.
Yes.
One annexed by you.
Yes.
Right?
Yes.
Now, firstly, though, this document at 20 doesn't seem to have been signed.
Yes.
But you are not saying that this is a fabricated document. You
Yes.
are giving an explanation.
Yes.
Now, where do I find that explanation in your affidavit?
Lordship. That perhaps, my lord, specifically not there.
No, but
Yeah,
this
but
is
this
something
the
you have to
mark.
clarify.
Yes.
You have to clarify because the court just cannot disown this document.
Yes, yes.
This is a document which you admit. Have you followed?
Yes, my lord, I got it.
And even here, you see some marks have been given.
Yes, page 20, my lord.
Now, in that case, you'll have to have the records.
The records are should be with the department, my lord.
You have the records. You have it. Now, does both these two comparative statement available in the record? Please mark it and give it. Flag it. Any explanation is there about what is this page 20 there? This one, the yellow flag is the which is signed by all, and the other one. No, what about the page 20 document which is annexed by the petitioner? Is it there in this record?
May I explain that?
Huh? Are you following? Because you see, it
Yes,
appears
yes.
there are some changes in the marks.
Yes, yes.
Now, allegations have been made,
Yes,
correct,
yes,
not
yes.
correct. the court has to look into.
Yes, my lord. That is my specific statement.
Now,
of the-
here also I find there is another comparative statement, English, which is signed this time by the VC. Here that the same marks given. 63.47, 62.63, and 62.47. But no, but where is this document? Page 20. Page 20 of the writ petition. Please show the. Because none of you have dealt with this in your affidavit. It's a document annexed in the writ petition. And they have said in paragraph 4 that on the day of interview, i.e. on 12 December 2020, candidates were given to know that the details of all applicants had been uploaded on the college website.
Yes, it was
Accordingly, a copy of the same was downloaded.
Yes, it was uploaded only to say who has applied, my lord. That is,
Wait, but
comparative statement.
it doesn't say that. It says details of all applicants, right?
Right.
And in that document which you had downloaded, that against the PRC, it says no. How subsequently that has become yes?
Well, PRC.
You see, mister, you
Yes.
have to explain
Yes,
all
yes.
this.
The PRC I have in the affidavit I have stated, my lord. Lordship will kindly turn to.
Because this court cannot disown the document at page 20. In
Yes.
fact, you are also not disputing.
Yes. Lord, regarding PRC, my lord, the applicant.
And on what basis this mark was given 61.47 to R5? And subsequently, how that mark became to 63 point something? Where is that explanation?
Because this was, my lord, what happened, my lord? Yeah, selection committee's marks.
No, you see, Mr. Counsel, whatever you are
Yes.
submitting has to be there on pleading.
Yes.
I'm asking from your affidavit, where is this explanation? How the mark has been changed from 61.47 to 63.47? Where is that explanation?
Because this was, my lord,
Where is the explanation? This court has to go by records. Where is that explanation? That is not there.
yes.
And anything there to show how this mark 61.47 has become to 63.47? Anything there in any of the notings? Because apparently, initially the mark was given 61.47 in respect of R5. Initially, there was a noting that PRC not given. Subsequently, PRC is said to be given. Mark has become 63.47.
Well, as regards PRC is concerned, that is there on record, my lord.
That is a different aspect, Mr. Counsel. We'll go to that later.
Yes.
First thing first. How did this mark from 61 has gone to 63? Where is that explanation?
But my specific instruction is that the final.
Instruction is something else. You have filed, you see, when you file an affidavit in opposition, you have to meet the allegations made in the petition,
Yes,
correct?
yes, that's true, my lord. That's
Now, where are those? If it is not there, this court will accept because it seems you have not denied. The court will accept the findings because it appears initially it was given 61.47. And for PRC, what is your explanation in your affidavit? Let us see.
Yes.
Anything there in the record?
Yes, my lord.
I have seen, I think one I have already flagged. I saw that is by the principal. But then what was this document? This document you had uploaded it in your website. From where he downloaded?
No, from the website of the college, my lord, not from the website of the DHC.
College.
Yes.
That is your.
Yes, yes.
So then on what basis the 61 was given?
So it was preliminary examination was.
Where is all that?
It is not on the basis of any provisions of law.
No, but
Yes,
how,
that's true, my lord.
how
that's
will
true.
the court
Yes.
see the selection must inspire the confidence of
Yes,
the
yes,
court,
that's
right? You have to come up with a plausible explanation. Whatever you are saying may be correct.
Yes.
But where is that?
Right.
Where are those explanations?
Regarding the MA certification, yes, the explanation is given in paragraph 5.
Paragraph?
5.
Paragraph 5.
Yes.
Yes, please read.
As regards the statements made in paragraph 5 of the petition, the answering deponent begs to state that the respondent number 5 submitted her HSLC, HSSLC, and integrated course BA 6th and 10th semester examination along with her application. Moreover, the respondent number 5 submitted her BA and MA integrated provisional plus certificate issued by the Controller of Examination, Prajpur University. It is stated herein that there were some confusion regarding the integrated mark sheet submitted by the respondent number 5, and therefore, when the mark sheets were evaluated, it was recorded that mark sheet has not been furnished. At page 20, it's reference to page 20, my lord. It is specifically stated herein that all the required educational qualification certificates were duly submitted by the respondent number 5 along with her application. Moreover, the selection committee on the date of interview compared the original mark sheets of respondent number 5 and the same were found to be in appropriate manner. As regards PRC, the answering deponent begs to state that the respondent number 5 along with her application submitted a separate application to the effect that PRC is not available with her at the present address, and the respondent number 5 assured that the same will be produced before the selection committee on the date of interview. Further, the answering deponent further begs to state that the selection of assistant professor is required to be made on the basis of UGC regulations. Such regulations enacted in exercise of powers so and so UGC Act. The object of the enactment for maintenance of standards of higher education, the provisions of UGC regulation mandate for selection on the basis of merit and minimum qualification laid therein. Such regulation nowhere mandates the requirement of a PRC as a qualification for such appointment. Inasmuch as there is no nexus between the standard of higher education, merit of the incumbent, and requirements of PRC. Therefore, on the count alone, the non-submission of PRC, the candidature of respondent number 5 cannot be rejected in as much as respondent number 5 on the date of interview produced the PRC before the selection process. But that application is annexed at, my lord, page 11, my lord. Page 10 is the typed copy.
This application is there in the record. This application is there in the record. This application is also not there. Yes, it's not there.
Is there. Subsequently, my lord, it was considered, and this honorable court, there is a judgment which has held that in case of PRC is required only for educational purpose. For employment, PRC is not mandatory requirement. But that judgment.
See, that is different. In the subsequent comparative statement, PRC is marked yes.
Yes.
This application is not even there. Your application, the R5's application, that she doesn't have it and she will later on give it at the time of selection, is not discernible from the records. Now, this court is only testing the decision-making process, not correct.
Yes.
Now, something is appearing to be not right because initially 61 mark was given, which was there in the college website.
Right.
They have downloaded it.
Yes.
That has become 63.47. No explanation how it has become 63.47. that document which you downloaded, which was in there, and the college thing is also not referred anywhere in the records
Yes.
of the selection.
But it was not a part of selection process, my lord, probably that's why that has not been considered, my lord. The selections as per the, my lord, extant law, it is the selection committee which decides the matter. Only the principal cannot evaluate anything, my lord.
Then on what basis this mark was given?
Only it's my lord, that is true, my lord, that has created all
Why,
the confusion.
correct, so why was that mark given? For what reason?
Yes, that ought not to have been
If the
given.
principal cannot evaluate, on what basis this mark of 61 was given and downloaded in your website? Uploaded in the
Yes,
website?
True, my lord, but that per
Because
se,
from there, a legitimate expectation came.
but per se, my
If
lord,
the petitioner started thinking that, yes, the petitioner has secured higher marks.
yes, that's true, but that itself, my lord, will not confer in my respectful submission any conclusive right, my lord.
That is another aspect, but why this confusion at the first place
Yes,
has
that
been
ought to have
brought?
been
Because you
avoided
have
or
your actions, if judged, has to show fairness. That's
that
all.
yes, that
Why
ought to
this
have been
confusion?
reflected clearly in the affidavit, my lord, that is there.
And no explanation.
Yes,
in your
yes,
affidavit.
that's,
So casual affidavit. Nothing is mentioned. Now you are saying all these things.
ought to have been there, my lord, I'll just read.
There is no doubt that that a selectee or a person who applies has no legal right.
Yes.
But
The
you are
process should be, my lord, transparent, my lord. It's
respondent
fair
was
confidence.
absolutely fair and transparent. Not even a whisper in your affidavit that these marks have been given on a preliminary basis, no explanation. When the entire crux of the matter lies on this document at page 20. This is from where they are showing that the respondent number 4's application is incomplete, that the respondent number 5 has secured less marks. The entire claim is based on this document. Correct, Mr. Mohanto, but where have they said so? No one has said so. Records will, you see, Mr. Mohanto, now they have done something, right? Now, nowhere it is mentioned. Nowhere it is mentioned. The record shows that subsequently marks have been changed.
No, not change, my lord.
Now, how do that quote?
That document, my lord, your lordship kindly see that.
Everyone has signed. Everyone has signed, right?
Yes.
Correct. But what was
How
the
61 to 63, that is there, my lord.
how?
Hey, your lordship kindly see. It is there, my lord, page 9, page my lord, 35. Page 9 of the Awa.
Yes, page 35.
Yes.
Yes, page 35.
Page 35, my lord, your lordship kindly CL number 12, my lord.
Yes.
That is 65, my lord. Academic. 61, 4 December, that is academic. Then, my lord, your lordship 5.5, these are in publication and other things, my lord, total lord was 63 point. That is your lordship, kindly see the heading, my lord. So she is not getting any publication and other marks, my lord. So that's why, my lord, in my affidavit, my lord, whatever.
No. Yes, yeah, an inference can be drawn, but these things are not coming out clearly,
Yes.
Mr. Mohanto. That is
No,
the
my
only
lord,
difficulty. Now,
affidavit, my lord, I have, my lord, the record which I have received, my lord, I have an annex, my lord. Your lordship
you
can
have
see
annexed what?
this document.
No, this document, no one is disputing now. The document at page 52, right? You are referring to the document at page
Yes, the
52?
comparative statement is
Yes.
referring.
Now, this document is available also in the records. I have already seen the records. In fact, the records also reveal individual markings, individual signatures of the members also. That is also there. Everywhere the mark is same, 63.47. There is no difficulty in that. But the only confusion started because of this page 20.
Yes.
And this page,
20, my lord, that is
that explanation,
unsigned document.
correct, but that explanation is nowhere. You see, there is an averment in paragraph 4 of the writ petition. Paragraph 4, right?
So no, my lord,
Mr. Mohanta, kindly see paragraph 4 of the writ
my
petition,
lord, your lordship
that
kindly
on
see-
the day of interview,
Before that, my lord, your lordship kindly see the heading of this, that matter.
page,
Page 20, my lord.
yes.
List of candidate applying for the post of assistant professor English unreserved, Department of English, sanction, so and so, that of so and so. The marks entered below are as per the marks entered in the document submitted by the candidates. And it may be changed after the verification of the original document by the members of the selection committee.
All right.
So that is there.
Why are you not pointing this
So
from
that's
so
why my
long?
so that means, my lord, actually what happens, suppose I am getting first division in metric, then it will be 60, it will come 6. So after the verification of document, it can be seen, well.
All right.
Before that, my lord, another aspect of the matter is in this case, I have to be pointed out, because here in this case, what happened, my lord, there is an order from this honorable court. He has already selected in different college. And also, if he, suppose, my lord, this petition are allowed, then, my lord, his serial number is 3. He's not, but person who is in
Yes,
second.
that person is not made a part.
So even after, my lord, he is allowed, then, my lord, he will not get any, my lord, opportunity. So that's why there is not asked to, my lord, this by this honorable court to, my lord, whether you are interested in or not. There is an order from this honorable court to clarify that, my lord. My honorable justice. Already she is getting job in another college.
Yes, what happened to this instruction, Mr. Chaudhary? I ordered it at 14.
My lord, we have been guided by the instructions that we have received. We have been guided by the instructions that we have received from our petitioner. Our petitioner is on pursuing this writ petition to its logical end, that she has been deprived of what was due to her. An injustice has been committed by the selection board altogether, and it is a fight against that injustice. And what will happen to the student community? The wrong person is selected and appointed to run the academic atmosphere of the college and institution. There is the order as such. We have been informed whether the petitioner, there is an extraneous cause, whether she will accept the job or not accept the job. There's outside.
Anything more? Anything more?
One thing, my lord.
Yes.
Lordship may kindly also refer to column that the petitioner is also a JRF awardee, my lord. And the respondent number 5 is not a JRF awardee. That point to be noted. A JRF, JRF, a junior research fellow, my lord. She has successfully and flying color has passed the NET examination. As such, she has been given the option of JRF, which is a fellowship. But then this petitioner, this respondent number 5, she could not make that grade. Over and above, my lord, our candidate were wrongly made 3. Wrongly she has been placed at 3rd position. And we have no relief to seek from the 2nd position holder. We have no relief to seek. Our relief is from the selection board.
NET you have cleared in 2019, Mr. Mohanta. This comparative statement shows.
There is no mark allotted for that, my. Suppose, my lord, your lordship kindly, however the mark is allotted, there is a government of India, Assam, there is circular high. Of that, my lord, it will be.
All right.
Moreover, there is another point, my lord, if your lordship allows me to speak about the point.
Yes, yes.
The petitioner has adopted, and then the petitioner has submitted 3 publications altogether, my lord. Those publications were overlooked by the selection board.
Court go into all this.
My lord, there is a
The
reference.
marks have been given.
My lord, I'm referring to that.
Only
That's one
the
point.
court
my
is
lord.
examining
Page
whether
112. It is on record, my lord. I'm referring to that point. Lordship may kindly refer to page 102.
And as per the
There's-
advertisement,
The
as per the advertisement, what is required? Qualifications.
qualification and the application must.
What is the qualifications required? Requisite qualification, adequate qualification and selection procedure will be as per so and so, with the NET/SET as mandatory eligible conditions.
Yes, ma'am.
It is
Submitting application.
it is an admitted position that R5 does possess the NET criteria. Then it says candidates having PhD degree in accordance with so and so standard and procedure for award of so and so regulation shall be exempted from this. The candidates must have minimum
have-
55% marks at master's degree level. This is also the R5 has.
Yes.
A relaxation is also there. The candidates have to acquire qualifications as on last date for submitting application. The MPhil so and so can be acquired and submitted so and so. There is no doubt about all this. These are the eligibility candidates. Then it talks about age and all. At the end, it says the candidates must have permanent residential certificate and must have
Proficiency in local language.
proficiency in local so and so in service must applied through proper channel. This is not an educational qualification. This is the requirement which it has to have. And apparently the R5 has submitted and the selection has done. Now, where does it talk about publications or not? Where in the advertisement? That is not there. R5 has these qualifications. And why have you not made the other person who is at serial number 2 a party? How can this court grant you the appointment? Even if you make a case, it will go. It will affect the right of serial number 2. Why serial number 2 person is not made a party?
Because you have no relief to seek from serial number 2, my lord.
But what is your relief
That
that
does
you
not
are
at all-
seeking, Mr. Mr. Chaudhary? What is the relief that you are seeking?
That
Please say your prayer.
This interview ought to be cancelled altogether because this
So
is
then-
faulty.
Who gets affected? Serial number 2 gets affected. Serial number, in case this court comes to a finding that the person at serial number 1 has been wrongly placed at serial number 1, then serial number 2 is there.
The serial number 2,
Serial number 2 gets affected.
serial number 2.
Then
My lord, serial number 2 is serial number 2's position is much lower than that serial number 2, in fact. Because her academic performance is much lower. And she has done her MPhil also in a subject other than English language.
sorry, Mr.
Over and
Chaudhary.
above, my lord, over and above, there is another point. The 3 publications, there is a faulty one, the erroneous one. There is manipulation altogether, adopting unethical means. I am substantiating it now. Page number 102. There, my lord. Respondent number 5 is awarded. Respondent number 5 is awarded based on 3 publications, supposedly only 2 marks. But those publications were not publications. They themselves admitted page 1 number 2. 1, my lord, is Kuntu.
Resume at 2. Yes.
Once permitted. I'd like to point out 3 flaws that have been taking place in the interview, resulting in wrongly manipulating the marks awarded to respondent 5. 1, page 30. Running page 30, the respondent 5 states that she has 3 publics. In page 102, the same respondent in a rejoinder affidavit tells that her publication has been only received, her articles have been received, not published. Apart from that, her publications also has been not published in university approved journals. That has been there in page 85. But the journals in which her publications have been published are phone journals, which are fake journals. They are not approved journals. Third, the petitioner's publications, which have been received by the interview board as per the principal's statement in page 118. She has received he has acknowledged that we have received the publications submitted by the petitioner, but those publications have been awarded marks. So 2 additional marks that the respondent number 5 is awarded is not only opaque, but also is manipulated. As such, the selection is vitiated by fraud, and as such, it should be set aside. This is my submission.
Take it down from.
Lordship wanted to me whether I have stated regarding that. My lord, that is there, my lord. On the basis of complaint filed by the petitioner, the Director of Higher Education asked for an explanation from the college. That the report has been annexed with a rejoinder affidavit filed by the respondent number 4. There, but they have already stated that only a tentative list was.
Where?
On page 118 of the rejoinder affidavit filed by the respondent number 3 and 4.
Page?
Internal page 118. A rejoinder affidavit was filed, running page. Lots of pleadings are there, madam. Rejoinder
118.
Internal page 12, Annexer B, running page 118.
Is Annexure B.
Annexer B. This is the response by the college to the on the matter. The petitioner filed a complaint before the DHE, pursuant to which DHE wanted an explanation. This is the explanation. This is the type copy, and original is at page below.
All right. Into item number 22 for disposal. Heard Mr. J.C. Chaudhary, learned counsel for the petitioner. Stop. Also heard Mr. T.J. Mahanta, learned senior counsel, assisted by MSP Bhattacharya, learned counsel appearing for the private respondent number 5. And Mr. A.D. Chaudhary, Mr. T. Chakraborty, learned counsel appearing for respondent number 3 and 4 within bracket Didibo. One second. So it is the college, within bracket college authorities, and Mr. S. Das, learned counsel appearing for the respondent, respondent number 1 and 2. Are you the standing counsel? Standing counsel, higher education. Huh? By way of this writ petition under Article 226 of the Constitution of India, the petitioner is assailing the selection and appointment of the respondent number 5 to the post of Assistant Professor English at Khagorijan College, Nagaon. Stop. The brief facts leading to the filing of the present writ petition are as follows. Pursuant to an advertisement dated 10/10/2020, whereby applications from eligible candidates were invited for filling up amongst others post of Assistant Professor for English subject. Stop. The petitioner having applied participated in the interview process and thereafter upon uploading the details of all candidates as were downloaded in the college website, comma, the petitioner came to know that it was up, thereafter, the respondent authorities which is the appointment order
Repeat, my lord, I have annexed.
On
Annex 3.
on date
Lord, the date is 16 February 2021.
by order dated 16/2/2021, appointed the respondent number 5 to the said subject post. It is the specific case of the petitioner that as per the details of all candidates, which was uploaded on the college website by the college authorities, it was apparent that the application of respondent number 5 was incomplete and the petitioner had secured more marks than the respondent number 5. Accordingly, the present writ petition has been filed. Mr. J.C. Chaudhary, learned counsel appearing for the petitioner, submits that the petitioner who secured higher marks in the subject selection having been ignored by the respondent authorities, while appointing the respondent number 5, whose application was incomplete, comma, the entire selection stands vitiated and the appointment of respondent number 5 is liable to be set aside and quashed. Stop. He further submits that though as per the details uploaded by the college authorities on the date of the interview held, it was apparent that the respondent number 5 had not submitted the requisite PRC application. However, it appears from the affidavit in opposition filed by the college authorities, that in the final that later on it appears that the said application is stated to have been filed by the respondent number 5. He accordingly submits that there has been gross manipulation of the records as well as the marks by the selecting authorities, and hence the entire selection is illegal, unfair, and arbitrary. Stop. Which paragraph have you said about the publication?
Paragraph 7.
No. Petitioner? That you had argued about the publication. Where have you said?
Page 102, first line,
Page 10,
and page 30,
page 102.
and page 30.
Page 102 is
Page 102.
page 102 is what?
Running
Affidavit, rejoinder affidavit.
It was and count.
Please answer to the query that the court is putting. Where have you pleaded that the publications are
She
wrong?
herself admitted, my lord.
Where?
She said that
No, in your pleadings, where have you stated in your pleadings? In your writ petition, you have not taken that ground. In the subsequent affidavits, if you have filed rejoinders, have you
no,
taken
my
this
lord,
ground?
I have not submitted my
You have not submitted that
I have
ground.
not. Rejoinder affidavit submitted by respondent 5.
You have not submitted.
I have pointed out that that is the fact.
Okay, fine.
And page number 30, she said that she had publications. And page number 1.
He further submits that the claim of the respondent number 5 that she has submitted the requisite publications is also appears to be not correct. Per contra, Mr. College authorities are numbered. First one, Mr. So-and-so, learned counsel appearing for the college authority submits that the list of details uploaded by the college authorities on the basis of which the petitioner claims to have secured higher marks than the respondent number 5 is totally misplaced inasmuch as the marks entered therein are as per the marks entered and documents submitted by the candidates, and the same is before the verification and the selection conducted by the selection committee. He therefore submits that the efforts, he therefore submits that the marks entered in the annexure P3 of the writ petition does not by any stretch of imagination give any right to the petitioner to claim to claim in support of the claim made in the writ petition. He further submits that after the selection committee had conducted the selection and verified all the documents, have found the respondent number 5 qualified and eligible, and has accordingly selected and has accordingly appointed the respondent number 5, and therefore the said appointment ought not to be interfered with by this court. Stop. Please don't interrupt when the court is dictating the judgment. Please don't. If there is any anything you want to point it out, you do it after the order is dictated. And I am only recording the submissions of the learned counsel. So don't unnecessarily interrupt. He further submits that the comparative statement of the selection committee in respect of the subject post abundantly clarifies that the respondent number 5 has secured the highest mark and is placed at serial number 1, whereas the petitioner is placed at serial number 3. He further submits that the person at serial number 2, i.e. Bhumika Devi, is not made a party respondent in the instant writ petition. He accordingly submits that non-impleting the person at serial number 2, comma, warrants no don't say warrants, disentitles the petitioner from grant of any of the relief sought in the present writ petition. Stop. Mr. T.J. Mahantal, Learned Senior Counsel, submits that the respondent number 2 has all the requisite eligibility, has all the requisite educational qualifications, and having secured the highest mark in the selection conducted by the selecting authorities, comma, the appointment of respondent number 5 to the subject post warrants no interference from this court. Stop. He further submits that since now I think that is all as far as no, who is serving? R5. He further submits that the respondent number 5, since her date of joining to the subject post is serving in the said post. He further submits that the petitioner in the meantime has been appointed as an assistant professor in English department in Tejpur College after going through a selection process and is accordingly serving therein. Stop. Mr. So-and-so, Learned Counsel for the respondent number 1 and 2 submits that places the records pertaining to the subject selection and draws the attention of the court that the details of candidates which was uploaded in the college website is not prior to the verification and selection by the selection committee. He further submits that the said document itself clarifies the aforesaid position inasmuch as the same is not signed by any of the members of the selection committee. He further draws the attention of the court that the comparative statement of the marks obtained by all the candidates, signed by all the members of the selection committee, clearly indicates that the respondent number 5 has submitted all the requisite documents and is also eligible for appointment to the subject post, and that after being evaluated, he secured first position in the select list, and hence the entire selection, being fair and transparent, warrants no interference from this stop. I have given my prudent consideration to the arguments advanced by the learned counsels appearing for all the parties and have perused the materials available on record. Stop. It appears that pursuant to the advertisement dated what is the date advertisement? 10/10/2020, comma, the petitioner and respondent number 5 applied for the subject post. Apt to refer to the aforesaid advertisement, which is reproduced hereunder for ready reference. A2A, page 19. A perusal of the aforesaid advertisement indicates that in order for a candidate to be qualified for the post of assistant professor, comma, the educational qualification will be as per Government Office Memorandum dated 8/11/2018 with the NET/SLET/SET as mandatory eligibility conditions. Stop. It appears that after the candidates have appeared for the interview, comma, the selection committee had conducted the selection and the comparative statement of selection of the subject post reads as hereunder. Quote unquote, page 52. A perusal of the aforesaid comparative statement, it is apparent that the petitioner is at serial number 3, whereas the respondent number 5 is at serial number 1, and it is apparent that the respondent number 5 secured the highest mark, and one Bhumika Devi secured the second highest mark, and the petitioner had secured the third highest mark. Stop. it further appears that it further appears that the respondent number 5 meets the requisite eligibility criteria, including NET clearance. Stop. This brings me to the contention of Mr. So-and-so Chaudhary, learned counsel for the petitioner, that it is apparent from the list of details of the candidates uploaded in the college website that the respondent number 5 secured lower marks than the petitioner and further did not have the requisite educational qualification. Stop. Apt to refer to the aforesaid document, which is enclosed as Annexure P3 to the writ petition. Quote page 20, Would chart continue 8 to 8. A perusal of the aforesaid document indicates that this was prepared on the date of interview before the verification of the original documents was done by the members of the selection committee, and the marks which were entered in this document are tentative and as per the marks entered and documents submitted by the candidates. It further appears that it is clearly mentioned in the document that the marks may be changed after the verification of the original documents by the members of the selection committee. That being so, the marks entered in these documents cannot by any stretch of imagination be said to be final marks awarded by the selection committee. In fact, the said document bears no signature of any members of the selection committee nor of the college authorities. Upon perusal of the records made available before this court by Mr. So-and-so, learned counsel appearing for respondent number 1 and 2, it appears that the selection committee, after verifying the documents, the original documents submitted by the candidates, have entered the marks on 12/12/20 on 12/12/2020, from which it is apparent that the respondent number 5 secured the highest marks. apt to refer to the relevant paragraphs of the affidavit in opposition filed on behalf of the respondent numbers 3 and 4, which reads as hereunder, quote unquote, 5, 6, 5 and 6. Perusal of the aforesaid averments made by the respondent number 3 and 4, it is apparent that the respondent number 5 has submitted all the requisite requisite testimonies as regards the educational qualification along with her application, and as regards the PRC, it appears that the respondent number 5, along with her application, submitted a separate application to the effect that PRC is not available at the time of submitting the application, and therefore assured that the same shall be produced on the date of interview. It further appears that on the date of interview, the said PRC application has been submitted by the respondent number 5. The issue involved in this writ petition is the validity of the selection. No, 1 second before that. It would be worthwhile to refer to the prayers, to the relief sought for in the present writ petition, which reads as hereunder, quote unquote, A to A, paragraph page 11. It appears that the petitioner has sought setting aside and quashing the appointment order issued in favor of the respondent number 5, and also has sought a mandamus for directing the respondent number 2 to issue a fresh appointment order in the name of the petitioner. As noted above, the candidate who secured the second highest mark and is above the petitioner is not impleaded as a party respondent in the present writ petition. In the event the prayer of the petitioner is given, a valuable right of the said candidate would be affected. Therefore, non-impleadment of the said candidate in the also non-impleadment of the aforesaid candidate on the score of non-impleadment of the aforesaid candidate, the writ petition can be dismissed. That apart, as noted above, the selection process appears to be fair and transparent. The action of the respondent in appointing respondent number 5 does not appear in the considered opinion of this court illegal, and therefore the writ petition lacks merit. Accordingly, the writ petition stands dismissed, no cost. You wanted to say something?
There is no record on the basis of which this electron list is prepared.
All right. Sorry. TJ Monta 5, huh? And you are 1 and 2, right? Just leave your records here for, you take it back after the court is over, huh? These are great.
Obliged. Item number 23.
Obliged, my lord.
Yes,
Meet
Mr.
with your
Chaudhary.
lordship. My lord, this is a petition claiming, my lord, regularization of service as a librarian in a college.
Librarian.
Librarian. The college was provincialized. All the teachers and non-teaching staff, their services have been regularized. He was left out. And my lord, no reason was ever assigned to it. And therefore, he approached this honorable court. His case is simple, my lord. He was appointed as an assistant librarian when the college was in venture stage. Then in the my lord resolution, the my lord appointing him, there was a condition that in the event you get a Master of Library Science degree within a period of 3 years, you will be upgraded as a librarian. So after taking leave from the college, he has completed that course. Subsequently, he has also obtained his PhD. That is not relevant. Then
Who's
my lord,
appearing for the other side?
Mr. K. Gogoi has been arguing this matter, Lordship. Now he is on break, Lordship. May I present some other day maybe?
As prayed for on behalf of Mr. K. Gogoi, which is not opposed by the other side, relist on.
any day convenient to your lordship.
Tell me when you want.
Wednesday next, my lord.
On Wednesday next.
Can it be after that?
Huh?
Can it be after that next, after 1 week?
Did you update it? Yes, next.
Item 24.
Lordship, my senior counsel is in legs in another court. So I request you to take the matter after some time, Your Honor.
As prayed for, list after 1 week on a date to be fixed by the registry. So call that matter Mr. Das's matter and Mr. Saronia's matter. I think they both are here now. Yes, which item number can I do? 20? No, I touch a Passover.
Passover. Item number 21.
Yes.
Please, Lord.
What is this matter?
Matter relates to my lord, appointment of the selection and appointment of private respondent 4 and 5, my lord. Well, it is a matter relating to the council, my lord. AAC, my lord. There is a one,
AICT.
my lord. So one, my lord, advertisement made for the one post of my lord assistant engineer, which prescribed the qualification is BE, my lord, from any institution, my lord.
Sorry?
Recognized institution, my lord. So thereafter, my lord, selection has been met, my lord, respondent 4 and 5. Accordingly, they have been appointed, my lord.
Mr. Chaudhary, you are for?
Four.
And Mr. Das, you are for the AICT? Huh?
5.
Who is for AICT? Okay. Yes.
My lord, the challenge before this, my lord, their selection is that, my lord, the advertisement only for one post, my lord. So they have appointed 2 posts, my lord. Secondly, my lord,
Advertisement is for one post.
one post, my lord. Then, my
Yeah.
lord,
And 2 persons were appointed.
4 and 5 has been appointed. Secondly, my lord, the prescribed qualification is, my lord, must be civil, BE civil from a recognized institute.
Must be what?
Must be BE civil, Bachelor of Engineering civil from a recognized institute, my lord. So, my lord, the respondent number 4, my lord, he is not a BE civil from BE civil, my lord. He is, my lord, that other AB, different, my lord, is not BE, my lord. So that's why this is under silence, my lord. As per the prescribed qualification in the advertisement, he is not qualified, my lord. Secondly, my lord, thirdly, my lord, when they have said that they have BE qualified on a recognized institute, my lord, that institute is not recognized, and that course also, my lord, not recognized, my lord, after, my lord, 6 and 7, my lord, session, my lord, because where he has admitted, up to 6 and 7, that institute was recognized. Thereafter, they are required to, my lord, extend the, my lord, that recognition. That has been not done, my lord. And secondly, my lord, that is a, my lord, extend education, my lord. That is distance learning education, my lord. Distance learning education in technical is not allowed, my lord, in technical subject, my lord. Because B is a technical subject. Only MCA and MCOM, it is allowed, my lord, as per university UC guideline, my lord. So here, my lord, let's come to annexure 1, my lord. It's an advertisement, my lord.
Page.
Page 21, my lord.
A. Yes.
My lord, there is, my lord, only one post, assistant engineer. Then scale of pay so and so, my lord, the age in so, then C, education qualification.
Yes.
Must be BE civil from a recognized institute, my lord. Thereafter, my lord, the petitioner also, my lord, being BE, my lord, they have also applied, my lord. Now, my lord, let's may come to, my lord.
R4, you are saying did not have BE civil.
My lord. 4 do not have, my lord.
4.
5 is he has, my lord, BE civil, but he is non-advertisement, he has been selected.
He is not?
That only one post is advertised, he has been, my lord, second post has been advertised, filled up by second, my lord, second post, my lord, though it is not advertised, my lord.
But otherwise, R5 is eligible.
My lord. There is no dispute, my lord, except the post, my lord, advertised.
And
Yeah.
as per select list, where is the select list? You are at what position? Are you eligible or are you not eligible?
My lord, select list was not that we published, my lord. We also, my lord, no knowledge about the select list, but we appeared, my lord, and
No, what is the stand of the respondent? Are you eligible or not eligible?
we are eligible, my lord. We have not said that we are not eligible. Only that, my lord.
The persons that see R4 and 5 has secured higher marks.
My lord.
Is that the stand of the respondent?
My lord. My lord. Then, my lord, let's come to annexure 5. Then we have doubting the, my lord, the qualification of the respondent number 4, my lord. We made an, my lord, RTA application before the, my lord, authority, my lord. The Director of Technical Education, Assam, my lord.
Yes.
Then thereafter, my lord, the in-person has been, my lord, provided. Let's may come to the next annexure 6, my lord. But the respondent number 4, my lord, all the documents, my lord, is from the Guwahati Institute of Technology. And there is no scope of franchisee also, my lord. Either he said that he has passed from the, my lord, Institute of, my lord, my lord, Institute of, my lord, Institute of Civil Engineers, my lord. That institute is from Punjab, my lord. The Institute of Civil Engineers, India, my lord. So as per AITC guideline, my lord, as per UGC University Grant Commission, my lord. So there cannot be a, my lord, franchisee institute outside of the jurisdiction of the state. If university is, my lord, established in a state, he has the jurisdiction, and in case of central university, that jurisdiction, my lord. So it is a, my lord, deemed to be university and private institution, it has an area, it cannot travel beyond the state, my lord. So there is no scope of franchisee. But all documents is, my lord, in his affidavit, my lord, for respondent number 4, annexed with that, my lord, that is Institute of Civil Engineers. He has passed out from Guwahati, my lord. Center is Guwahati. Specifically in his marks and lordship may come to page 78, my lord.
No, I have still not followed whether the R4 has this civil engineer.
No, my lord.
Huh?
No, my lord. There is a
Is that an
course, my
admitted
lord. This,
position, Mr. R4, Mr. Chaudhary? You're appearing R4. Is that an admitted position?
Yes, ma'am.
You don't have that.
No, ma'am, but I have the eligibility for your lordship.
No, eligibility will come, but this particular degree, which is there in that advertisement, BE Civil from a recognized institute.
Right.
Do you have that?
Yes, ma'am.
You have
my
it.
lord, that the certificate from the Institute of Civil Engineers that has been recognized and my lord,
From which institute?
my lord, associate, my lord, this is certificate A and B of the associate membership under the Institute of Civil Engineers, Ludhiana.
And so then the entire issue which will fall for determination is whether that is a recognized
Yes.
university or not.
Yes.
That is the short issue
That
that,
is the issue.
huh?
That is-
Isn't it? Yes.
my lord, this is, my lord, the associate membership of engineers is, my lord, they say that equivalent to BE, my lord, in case of civil, my lord. So equivalent to BE. But in the advertisement, my lord, only prescribed qualification BE civil, not equivalent to so and so, my lord. So, my lord, this is there, all the mark sheet, my lord, have shown
So
that
if
it is
is
from Guwahati.
How can you say it is not eligible?
No,
He
my
has
lord,
an equivalent
because,
degree.
because as in the advertisement, they have not prescribed, my lord. If it is been prescribed or equivalent, any word, my lord, specifically. So there is no, according to advertisement, they have to, my lord, recruit the person, my lord.
No, but if that university is a recognized university,
My lord, it is not a recognized, not recognized institute, my lord. They deemed university, but not recognized, my lord.
all right.
Then my lordship, on replied, my lord, they have said that as he has passed out from the Assam Guwahati Institute of Technology, my lord. That is a franchisee of that, my lord, Institute of Civil Engineers, India, my lord. Punjab, Ludhiana, my lord. Thereafter, my lord, lordship may come to the appointment order. Annexure 8, page 32, my lord. This is the
So
appointment
what is
order,
the information sought? And I'm still at page 30.
my lord.
What does it mean? Number one, it says Assam Institute of Technology and Guwahati Institute of Technology are not found in the approved list of AICTE. And they are not recognized by Directorate of Technical Education Assam.
My lord.
Now,
Well, as he has passed out from the Guwahati, my lord, we made a query, my lord.
so they are saying it is not
not
the
recognized by AICTE. There is no records in technical education of Assam, my lord, regarding this.
And this, which is the document, it shows that the respondent number 4 has passed out from this institute.
74, page 74.
Page 74.
74 and 5, my lord, his mark sheet, my lord.
74 and 5. 75. Okay, fine.
There are 3, 4, 5 mark sheet, my lord, all are in from Guwahati Center.
Okay. Equivalent to degree. Associate membership examination civil equivalent to degree. Institute of Civil Engineers in India. Examination center you are showing.
My lord.
Guwahati. Yes.
My lord. Then my lord should come by page 32, my lord. 31 is my representation, our representation, my lord, from the association, my lord. This is the appointment order, my lord. The post is advertised for 1, my lord. They have appointed 2, my lord. The respondent number, my 1 is the respondent number 4, 2 is the respondent number 5, my lord. Now, my lord, again we have made a query, my lord, by filing the my lord RTI. That information is, my lord, in Annexure 10, my lord. Annexure 9 is the, my lord, RTI application from AICTE, my lord.
Annexure?
My lord, Annexure 10, page 34. The query is this, my lord, is institution, my lord, 1 is Institution of Civil Engineer Ludhiana, Punjab recognized by AICT after 31/5/2013? Second, does degree or diploma conferred to students after 3/5/2013 by Institute of Civil Engineer Ludhiana, Punjab recognized by AICT? Does AICTE approve of institution necessary while obtaining degree or diploma? Now, information provided. Right hand side, my lord. The Institution of Civil Engineer Ludhiana, Punjab is not approved institution by AICTE. Therefore, the required information is not available in AICTC NWRO Chandigarh. So, my lord, this is not a recognized, this is required to be recognized by AICTC, my lord. Thereafter, my lord, there is a one document, my lord, that annexure 12, my lord, where, my lord, the recognition has been given for only for 6 and 7 in case of, my lord, that associate member certificate course, my lord, to some of the institute, my lord. May I read the, my lord, because very crucial document this one. On recommendation of the high-level committee for recognition of educational qualification in its meeting held on 22nd May 2007, the government of India decided to give recognition to section A and B associate membership equivalent to degree part 1, part 2 of technician engineer, equivalent to diploma in civil engineer and architect engineer course conducted by Institute of Civil Engineer Ludhiana, Punjab, where my lord, the respondent number 5, my lord, said to have got the degree, my lord. As per syllabus approved by the All India for the Technical Education AICTC with effect from academic session 7 and 8, 2007 and 8, my lord. For the purpose of employment to the post and the service under central government in the appointment field, it is subject to the condition that the total number of candidates who can be admitted for the said examination would not exceed the authorized strength of the concerned institutions with which Institution of Civil Engineers India, Ludhiana, Punjab has entered into memorandum of understanding. A review in respect of the recognition of the educational institution shall be made by the Ministry of Human Resource Development after 1 year to All India Council of Technical Education. My lord, in this case, my lord, assuming that, my lord, they have the approval, my lord, of the AITC, my lord, or, my lord, University Grant Commission, my lord, from the Ministry of Human Resource Development, my lord. So it is at the last line, but a review in this respect, recognition of educational qualifications shall be made by the Ministry of Human Resource Development after 1 year to All India Council of Technical. That review has not been done, my lord. There is no proof, my lord, even from the AITC, my lord. They have filed affidavit. There is no whisper that after 2007-8, that year recognition, as per is required to be reviewed, they have reviewed. That's why it is a recognized institute. Apart from, my lord, BE and, my lord, associate membership, that difference, my lord. This institute not at all recognized, my lord. Lordship, that here is a one, my lord, letter from the Ministry of Railway, my lord. They are saying that we are accepting the associate membership, my lord, that as a equivalent to B in case of their employment. So that is also, I think, my lord, they are taking the, my lord, that if they are railways appointing, why not in another? Maybe, my lord. But here also some restriction is there, my lord. Lordship, may come to the, my lord. This is issued by the Railway Board, my lord. The page 38, my lord. This is only for railway purpose. They have issued this, my lord. Issued to the general manager, my lord. My lord, the all junior railway, my lord, chairman all railway recruitment board by the, my lord, joint director of railway board, my lord. Here, my lord, said then, my lord, the issue of acceptance or otherwise of following courses awarded by institutions cited above for the purpose of employment on railway has been under examination of this ministry. Course conducted by Institute of Civil Engineers India, Ludhiana, Punjab. The section A and B associate membership BE civil engineer or BE architect engineer. Part 1, part 2 of
So this is
technician.
on that, on this basis, they are saying it's equivalent.
That is, my lord. They
Huh?
are saying equivalent, my lord. They are saying they are going to recruit also, my lord, if they have got. But here, last line, my lord, up to 2000, 2007, my lord. That recognition should up thereafter, no, my lord. The matter has been examined in consultation with the Department of Higher Education, Ministry of Resource Development, and it is clarified that candidate who has obtained qualification from the aforesaid institution during the academic year 2007 and 8 only shall be considered for employment as per the prescribed qualification for the post. So after 2007 and 2008, there is no, my lord, recognition from the UGC or AITC, my lord, in respect of this institution, my lord. My lord, there is a public notice, my lord, Annex 14, my lord, page 40. So that has been not given, my lord. Later on, I have verified from one judgment of the, my lord, Supreme Court. It is issued on 6/10/2010, my lord.
Yes,
Married, my lord.
yes.
It has come to the notice of All India Council for Technical Education that certain universities / state universities / deemed universities / institution are giving misleading advertisement in newspaper for admission in technical education program in distance mode, indicating that they have approved of the Joint Committee of UGC, AITC, DEC for various programs. It has been the policy of the AICTE not to recognize the qualification acquired through distance education. So
if for some reason this court finds that R4 is not eligible for some reason,
my lord,
but R5 is already there, you are not saying the R5 is not eligible, and one post is already advertised.
My lord, R5 is, my lord, the qualification we are not making any
Then-
doubt, my lord, regarding post is advertised because in the second post without advertisement has been.
How do you
appointed.
say that R5 is appointed against the second post and not the first post? Because of the serial number.
Because the serial
So,
number.
but if R4 goes, then R5
No, that's
will
why, my
come.
lord, in the, my lord, appointment order, the 4 is in the top, 5
What
in the
is the
second.
explanation for the two posts when the advertisement was for one post? Yes.
Page 54.
Page
54.
fifty-four.
54.
Affidavit filed by
Respondent number 1 and 2.
1 and yes.
Paragraph
Sorry.
4. I'm reading.
Yes, please.
That the deponent basis said the respondent number 4 and 5 have secured first and second position respectively on the basis of merit cum performance in the viva test, whereas the petitioner number was in the 17th position. The petitioner number 3 in the 15th position, petitioner number 4 in the 13th, and the petitioner number 5 was in
You are
the
reading which paragraph 4?
paragraph 4.
Yes.
The respondent number 4, Lordship,
Yes, yes.
the petitioner number 4 in the 13th position and petitioner number 5 was in the 8th position. It is pertinent to mention here the petitioner number 2 who has not participated in the viva test. The office of the person department has no copy of the particulars not in the forms of the said petitioner. There are 5 other successful candidates in the merit list above the petitioner number 1, 3, 4, and 5, and they were not included as respondents.
Not included.
Not included, my lord. Not included as a respondent in the present writ petition. Next one, paragraph 5. That the validity of the merit list prepared by the selection board on 25/3/2017 was extended by the authority of KSC for a period of 1 year. The office order extending the validity of merit list was issued by the respondent number 2 by memo dated 16/9/2017. That though the advertisement dated 17, paragraph 6, 17 to 2017, it was mentioned that one post of assistant engineer was vacant, but due to the promotion of the incumbent from the assistant engineer to the super engineer, after creation of the post of super engineer, another post of assistant engineer became vacant, and the respondent number 4 and 5 were appointed against the 2 sanctioned vacant post of assistant engineer civils work department in Seretium from the merit list dated on the basis of the merit position secured by them by dated.
That's on the basis of merit.
That the deponent makes to state that in respect of the degree awarded by the Institution of Civil Engineer Ludhiana, it is stated that respondent number 2 filed his letter number dated 4/5/2017 wrote to the Undersecretary to the Ministry of Human Resource Department, New Delhi, seeking confirmation regarding recognition of the degree awarded by the Institution of Civil Engineers Ludhiana. In pursuance of the letter dated 4/5/2017, the Undersecretary stated that Ministry of Human Resource Department has recognized some courses conducted by the Institution of Civil Engineers Ludhiana beyond 31/5/2013. That is the date, my lord. Therefore, the respondent number 4 was enrolled in the Institution of Civil Engineers Ludhiana on 14/7/2008.
Where is this letter?
Later we have annexed, my lord. Letter is there. And he has passed section A and B of associate memberships examination.
Which
in
is
civil engineering.
equivalent to B civil.
Equivalent to BE degree, my lord. A degree in civil engineering examination held in summer 2016. Next, paragraph 8. That the Joint Secretary Government of India filed notification dated 6/11/2007 notified that the Government of India has decided to give recognition to section A and B of the associate membership course equivalent to the degree and part 1 and 2 of the technical engineers equivalent to diploma in civil engineering and architectural engineering courses conducted by the Institution of Civil Engineers Ludhiana, Punjab, as per syllabus approved by AICT, with effect from the academic session 2007-8 for the purpose of employment to the post of services under central government in the approved appropriate field. By office memorandum dated 6/12/2012, the Undersecretary to the Government of India, Department of Higher Education of Ministry and Human Resource Development clarified that all those students who are enrolled with the institution with permanent recognition up to 31/5/2013 would be eligible for consideration in accordance with the notification dated 16/11/2007. My lord, that is the point. My lord, next paragraph. The Joint Secretary Personnel A Department had his letter dated 4/5/17 wrote to the Undersecretary to the Government of India, Department of Higher Education, to confirm whether the Institution of Civil Engineers Ludhiana has been approved by the AICT or not. The Undersecretary to the Government of India, Department of Higher Education, by letter dated 9/5/2017, confirmed the issuance of notification dated 6/11/2007, by which some of the course conducted by the students of Ludhiana were recognized by the Ministry of Human Resource Department for the purpose of employment in central government. The Assistant Director, All India Council for Technical Education, by his letter dated 1/8/2017, clarified that the Director of Technical Education, Government of Assam, that the matter of granting recognition to professional bodies such as ICI comes under the purview of the MSRD, Government of India. That the Undersecretary to the Government of India, Department of So on dated 15/6/2017 informed the Director of Technical Education, Government of Assam, that the courses conducted by the Institution of Civil Engineers Ludhiana, Punjab were recognized by the Ministry of Human Resource Department for the purpose of employment in central government. It is also clarified that the MSRD issued the office memorandum dated 22 where it is clarified that all those students who are enrolled with the institution with permanent recognition up to 31/5/2013 would be eligible for consideration in accordance with the notification dated 22. The respondent number 4 was enrolled in the Institution of Civil Engineers Ludhiana on 14/7/2010 in section A and B associate membership course in civil engineering, and he has completed the said examination held in the summer 2016. So during the validity period of recognition, my lord, the respondent number 4 was, my lord, obtained the degree, and it is the recognized degree. If you lordship look into the Annex 5, page 63, that is the letter wrote to us, my lord, by the central government, that the
Page 63.
Page 63, my lord.
Yes.
The second paragraph, my lord, office memorandum dated 6/12/2012, wherein it is clearly mentioned that all those students who are enrolled with the institution with permanent recognition up to 31/5/2013 would be eligible for consideration in accordance with the MSRD office memorandum in force pertaining to their course for equivalence in central government job. And it show the qualification of the, though in the advertisement it is mentioned that the BE in civil, but the AMI degree obtained from the particular institution is recognized by the central government. So as he secured the first position in the merit list, he was appointed. So during that validity of the, my lord, merit list, another post was vacant, and by the petitioner, respondent number 5 was appointed in that particular post. The petitioner participated in the selection process, and he was
There are
not
5
selected.
candidates on top
my lord, and he has not made the party also the other persons who were in his above in the merit list. And my lord, and he is participating in the selection process. As he was not selected, subsequently he filed a repetition, so the petition is liable to be dismissed. In the case of modern law, in that particular cases, they are my lord. I'm relying in that particular case.
All right. Yes, Mrs. Saranya, I'm sorry that I had cut you short, but
My lord,
you can
my lord.
complete your arguments and also reply to Mr. Shutia also.
My lord.
Yes.
My lord, here this document is, my lord, they have on their query they have met, my lord. But the official document is said, my lord, there should be a permanent recognition up to 31st May 2013. 1/6, there is not applicable anywhere.
But that document which says beyond 31 is also recognized.
My lord, that is true in case of others, but in case of Punjab, Ludhiana, where is the, my lord, after 7 and 8, there is the recognition has been continued, my lord, till 31st May
But,
2013.
Why you have not implemented the other candidates who were above you all?
My lord,
They
because
have
of,
a right.
no, because they have the
Because
right.
suppose you succeed, this court cannot grant you appointment. You will not get any, if the relief that you are seeking, how can this court grant?
My
When
lord,
there are other candidates.
my lord,
And as regards the two posts, it appears that the select list was extended, right? And then thereafter a post stood vacant.
my lord, making a party, my lord, this is, my lord, only reason that, my lord, post is one. The
Even if there is
fifth
one
is the, my lord,
post,
fifth is the second, my
even
lord,
if it's the one post,
my lord.
in that situation also, none of the petitioners would get it. There are others. What is the relief that you're seeking in this writ petition?
Because my post is one, person be selected to other with the next
To
person will
quash
come,
the impugn appointment of order of dated so-and-so of private respondent 4 and 5 to direct particularly respondent number 2 to hold the fresh interview. Now, if this direction is given, then the persons who are above you, their right is getting affected. They were selected.
my
They
impression
have
is,
secured higher marks.
my lord, my is not making the other party, there is only one post. Suppose, my lord, the respondent number 5, we are not doubting his qualification. Only we are making a categorical statement, one advertisement is coming in the, my lord, second post. So there is no second post advertised. Even, my lord, the respondent 4 is been found to be, my lord, not eligible. The otherwise, my lord, respondent come. But one thing is, my lord, being a, my lord, be qualified, we have a right to challenge, my lord, because of, my lord, the one illegality cannot be go.
But what
I am
about
a
the
candidate.
other candidates? You have not implemented them. That is the query of the court. How can the relief be given? Fresh selection.
All candidates.
Their rights are getting affected.
Only, my lord, the affected candidate is the, my lord, respondent number 5, my lord. Respondent number 5, my lord.
No. There are more candidates who are on top of the petitioners. 5, total 5. Mr. Chutia, total 5?
There are 4 of council secretary.
Total, how many total? 5.
His position is 17 and 15. 5 petitioners are there. Petitioner number 2 not participating by voice.
No, that I have seen. Mr. Chutia has referred that paragraph, but in total, how many are above them? 5, correct. 5 are there. Mr. Das.
There are other 5 successful candidates. Yes.
Total candidate.
Total candidate was 17, my lord. Petitioner is the petitioner number 1 is the last position.
17.
17 position. Total 17 candidates.
You have to satisfy first that.
My lord.
You have to first satisfy the court on that.
My lord, one is about substantive illegality, my lord. Because
satisfy that first. That's what I'm saying. If you want to bring any authority, you can place it.
No, my lord. When there is a, my lord, something, my lord,
procedural
difficulty, my lord. Procedural lapse, my lord. That is different thing, my lord.
Counsel, it could one could have understood sometime there are thousands of selectees and then a common publication is done or something that can be understood. These are 5 people, 5 persons. Details of them are available.
No, my actually, they, to my understanding, my lord, what I have got instruction from my client, they have not published, my lord, but they have only appointed. Later on, they have making the category, even they have also not annexed, my lord. They may making a categorical statement, my lord. We are not aware of this, that how many candidates appeared. We know
Where
that
have you said
except
that
one,
in your petition?
my lord.
Where have you made that averment in your petition?
Environment, my lord.
We will continue the hearing on Tuesday. Tuesday, Mr. Chaudhary? No further accommodation on Tuesday. You have whatever authorities you want to rely. Be ready with everything.
My lord.
List heard in part, list on Tuesday date to read, huh? Such and such date. I'm keeping this, and in case since the weekend is coming, any one of you want to submit a written short one-page note or anything, please submit it on the next day.
Seven years, 8 months. The respondent number 5. There'll be more people. So even if it is kind of beyond the.
Mr. Das, ask your junior, Mr. Das, to just prepare, give it along with a small note, whatever you want to say.
That is can be differentiated.
Mr. Chaudhary, I think there is some case where even if one post is given and subsequently a post is stands vacant, I think that can be, there is some decision, I think. Please have that decision also.
Such that because of the period, period of.
That comes, that is another aspect, but you see, all these are grounds if taken, this court has to adjudicate also.
The main ground is again respondent hopeful. That's what the whole petition is on.
Now, if that goes and you want to come in, then that question which I'm asking Mr. Chaudhary will come in. Because you are against the second post.
But petition has been made clear by the Supreme Court. Even illegal things have been committed.
All right, you please it.
Hello.
Yes, Mr. Sahewala.
Hello. My lord, this is against an order, my lord.
It's going to take time.
It will take time.
Then we can have it on another date.
Fine. In fact, my briefing counsel is also, my lord, unwell today.
Do you see paucity of time for it? When do you want it?
Next week, my lord, any day convenient to your lordship.
At the date of next week.
8 May. Okay.
Just 26 and 27. Watch out.
Yes.
May I please, your lordship? Lordship, we are being led by our senior, Mr. K.N. Chaudhary. He's in election court number 14.
All right, when do you want it?
After some time, lordship.
This is the last matter on board.
Next week, can you take lordship?
Next week on board for after next week for next
After 10th one.
13.
I'm obliged.
Supplementary is item number 31.
Yes.
Today I need some explanation, my lord. Senior counsel has some difficulty, my lord.
Your name?
DJ Mehdi. Can it be
As prayed for by Mr.
DJ Mehdi.
DJ Mehdi, learned counsel for the petitioner, relist on such and such date. Monday would be difficult next week. Not it week, not it Monday did you?
Much of it.